when they're only 22% of the population. That's the way they designed the law. The more you spend, the more you get. What does it mean for the people of South Carolina? If you had a per patient formula where you got the same amount from the federal government to the state, whether you lived in Charleston, Columbia, or San Francisco, or New York City, if you leveled that out, it'd be almost $1 billion more for us in South Carolina. So to my friends over there, we're going to fight back. We want our money. If you're going to have money allocated for Obamacare, we're not going to sit back and quietly let you give 35% of it to 3 states. What else has happened in South Carolina? 4 rural hospitals have closed because the revenue streams are uncertain. 30% increase in premiums in South Carolina for those on Obamacare. I was on Obamacare for a few years before I got on TRICARE. My premiums went up 300%. My coverage was almost non-existent, a $6,000 deductible. If you're going to have so I want a better deal. And that's a political fight. I'm in a campaign at home. If it were up to me, we would block grant this money, send it back to the states in a more fair allocation, and we would require pre-existing conditions to be covered as part of the block grant. We want sick people covered, but I got an idea. I think South Carolina may be able to deal with diabetes better than and different than California. If you want good outcomes in medicine, you need innovation. And the best way to get innovation is to allow people to try different things to get better outcomes. So the debate on health care is consolidating all the power in Washington, have some bureaucrat you'll never meet running this program versus having it centered in the state where you live. Under my proposal, South Carolina would get almost $1 billion more. The state of South Carolina would be in charge of administering Obamacare. They couldn't build football stadiums with the money. They have to spend it on health care. They'd have to cover pre-existing conditions. But if, as a patient in South Carolina, you would have a voice you don't have today. If you didn't like what was happening to you on the health care front, you could go to local officials and complain. And the people you're complaining to live in your state. They send their family to the same hospital as you go. That's a structural difference. That's got nothing to do with this hearing. It's got everything to do with politics. We on this side do not believe Obamacare is the best way to provide quality health care over time. Our friends on the other side, this is a placeholder for single-payer health care. If you don't believe me, just ask them. So that's the fight going into 2020. Doesn't make them bad, it just makes them different. If we're up to me, bureaucrats would not be administering health care from Washington. People in South Carolina would be running health care. If it were up to me, we'd get more money under Obamacare than we do today. 35% would not go to 3 states, and sick people would be covered. So that's our friends on the other side. We're involved in a campaign in South Carolina. Single-payer health will be left up to the people of South Carolina. So that's what Obamacare is all about. Now, how do you play in here, Judge? There's a lawsuit involving the Affordable Care Act before the Supreme Court, and we'll talk about that in a bit. And the difference between analyzing a lawsuit and having a political argument is fundamentally different, and I hope to be able to demonstrate that over the course of the day. And I hope that my colleagues on this side of the aisle will not feel shy about telling my colleagues on the other side of the aisle why we think we have a better idea on health care. Now, the bottom line here, Judge, you said yesterday something that struck me, and I want the American people to understand what you meant. You said you're an originalist. Is that true? What does that mean in English? Pass the button. I mean, we all love Senator Lee, but in English.
In English. Okay, so in English, that means that I interpret the Constitution as a law, that I interpret its text as text, and I understand it to have the meaning that it had at the time people ratified it. Okay. So that meaning doesn't change over time, and it's not up to me to update it or infuse my own policy views into it.
So in other words, you're bound by the people who wrote it at the time they wrote it. That keeps you from substituting your judgment for theirs. Is that correct?
Yeah.
All right. Justice Scalia, he was an originalist, right?
Yes, he was.
People say that you're a female Scalia. What would you say?
I would say that Justice Scalia was obviously a mentor. And as I said when I accepted the president's nomination, that his philosophy is mine too. You know, he was a very eloquent defender of originalism. And that was also true of textualism, which is the way that I approach statutes and their interpretation. And similarly to what I just said about originalism, for textualism, the judge approaches the text as it was written with the meaning it had at the time and doesn't infuse her own meaning into it. But I want to be careful to say that if I'm confirmed, you would not be getting Justice Scalia, you would be getting Justice Barrett. And that's so because originalists don't always agree, and neither do textualists. Justices Scalia and Thomas disagreed often enough that my friend Judge Amul Thapar teaches a class called Scalia versus Thomas. You know, it's not a mechanical exercise.
Well, I'll wait till the movie comes out. The bottom line for me is there's a narrative building in this country, and again, you can stand down. This is just me speaking for me. Justice Ginsburg was an iconic figure in American history, just not the law. She was a trailblazer. She fought for better conditions for women throughout society. She was unashamedly progressive in her personal thought. She was devout to her faith. She worked for the ACLU. She was proudly pro-choice personally. But all of us on this side, apparently when they voted, accepted that she was highly qualified. What I want the American people to know, I think it's okay to be religiously conservative. I think it's okay to be personally pro-choice. I think it's okay to live your life in a traditional Catholic fashion, and you still be qualified for the Supreme Court. So all the young conservative women out there, this hearing to me is about a place for you. I hope when this is all over that there'll be a place for you at the table. There'll be a spot for you at the Supreme Court like there was for Judge Ginsburg. And to President Trump, I don't know if you're listening or not, by picking Judge Barrett, you have publicly said you find value in all of these characteristics, but beyond anything else, you find Judge Barrett to be highly qualified. I would say you're one of the greatest picks President Trump could have made, and from the conservative side of the aisle, you're one of the most qualified people of your generation. Let's talk about Brown versus Board of Education, because I know Senator Blumenthal will. I'm going to talk about that. You said in writings it was a super precedent. What did you mean?
Well, in my writings, so as a professor, I talked about the doctrine of stare decisis. And super precedent is not a doctrinal term that comes from the Supreme Court. And I think maybe in political conversation or in newspapers, people use it different ways. But in my writing, I was using a framework that's been articulated by other scholars. And in that context, super precedent means precedent that is so well established that it would be unthinkable that it would ever be overruled. And there are about 6 cases on this list that other scholars have identified.
Let's talk about Brown and talk about why it would be unthinkable. First, let's talk about what's the process that would lead to it being overruled. What would have to happen?
For Brown to be overruled, you would have to have Congress or some state or local government impose segregation again, open segregated
Okay, let's stop
schools.
right there. If you want to make yourself famous, by the end of the day, you can say we want to go back to segregation. I promise you, you'll be on every cable TV channel in America. I doubt if you'll go very far, but the point we're trying to make here is the court just can't wake up and say, let's revisit Brown. It has to be a case in controversy. Is that right?
Yes, that's right.
So before a Brown decision you could review Brown, somebody out there would have to be dumb enough to pass a law saying, let's go back to segregated schools. Is that fair to say?
That is fair to say.
Do you see that happening anytime soon?
I do not see that happening anytime soon.
Yeah, I don't either. So let's talk about the process in general. There's the Heller case. What's that about?
The Heller case is a case decided by the Supreme Court, which held that the Second Amendment protects an individual right to bear arms.
Okay. Now, my friends on the left, some of them have a problem with Heller. They may try to challenge the construct of Heller. If a state or local government passed a law in defiance of Heller, what would happen?
In defiance of Heller,
or that was challenging the construct of Heller?
That challenged the construct of Heller. If it was brought in a lower court, Heller binds. I mean, lower courts always have to follow Supreme Court precedent, and so.
And if the Supreme Court wanted to revisit Heller, what would they do?
If someone challenged Heller below because a state or local government passed a law contradicting Heller, the Supreme Court would have to take that case once it was appealed all the way up. So the court would have to decide, yes, we want to overrule Heller, and we have enough votes to grant cert, and then do so.
So that's the way the process works.
Yes, it would start because there was a law, then there was a lawsuit, then there was an appeal, then the court granted cert, and then the court decided the case.
Is that true no matter what the issue is, whether it's gun, abortion, health care, campaign finance? Does that process hold true for everything?
Yes, judges can't just wake up one day and say, I have an agenda, I like guns, I hate guns, I like abortion, I hate abortion, and walk in like a royal queen and impose, their will on the world. You have to wait for cases and controversies, which is the language of the Constitution, to wind their way through the process.
All right. Well, Senator Sass gave us a good civics lesson. I hope that's the basic lesson in law here. So if a state said, I don't think you should have over 6 bullets, and somebody believed that violated the Second Amendment, there would be a lawsuit and the same process would work, right?
The same process would work. In that case, parties would have to sue the state who, arguing that law was unconstitutional. It would wind its way up. And if it got to the Supreme Court, and if the Supreme Court decided to take it, a whole decision-making process begins. You hear arguments from litigants on both sides. They write briefs. You talk to clerks as a judge. You talk to your colleagues. Then you write an opinion. Opinions circulate, and you get feedback from your colleagues. So it's an entire process. It's not something that a judge or justice would wake up and say, we're hearing this case. I know what my vote's going to be.
Let's talk about the 2 Supreme Court cases regarding abortion. What are the 2 leading cases in America regarding abortion?
Well, I think most people think of Roe versus Wade, and Casey is the case after Roe that preserved Roe's central holding, but grounded it in a slightly different rationale.
So what is that rationale?
Rationale is that the state cannot impose an undue burden on a woman's right to terminate a pregnancy.
Okay, unlike Brown, there are states challenging on the abortion front. There are states that are going to a fetal heartbeat bill. I have a bill, Judge, that would disallow abortion on demand at the 20 weeks, the 5th month of the pregnancy. We're one of 7 nations in the entire world that allow abortion on demand at the 5th month. The construct of my bill is because a child is capable of feeling pain in the 5th month, doctors tell us to save the child's life, you have to provide anesthesia if you operate because they can feel pain. The argument I'm making is if you have to provide anesthesia to save the child's life because they can feel pain, it must be a terrible death to be dismembered by an abortion. That's a theory to protect the unborn at the 5th month. If that litigation comes before you, will you listen to both sides?
Of course. I'll do that in every case.
So I think 14 states have already passed a version of what I've just described. So there really is a debate in America still, unlike Brown versus Board of Education, about the rights of the unborn. That's just one example. So if there's a challenge coming from a state, if a state passes a law and it goes into court where people say this violates Casey, how do you decide that?
Well, it would begin in a district court, in a trial court. The trial court would make a record. The parties would litigate and fully develop that record in the trial court. Then it would go up to a court of appeals that would review that record looking for error. And then, again, it would be the same process. Someone would have to seek certiorari at the Supreme Court. The Supreme Court would have to grant it. And then at that point, it would be the full judicial process. It would be briefs, oral argument, conversations with law clerks in chambers, consultation with colleagues, writing an opinion, really digging down into it. It's not just a vote. You all do that. You all have a policy and you cast a vote. The judicial process is different.
Okay. So when it comes to your personal views about this topic, Do you own a gun?
We do own a gun.
Okay. All right. Do you think you could fairly decide a case even though you own a gun?
Yes,
All right. You're Catholic.
I am.
I think we've established that. The tenets of your faith mean a lot to you personally. Is that correct?
That is true.
You've chosen to raise your family in the Catholic faith. Is that correct?
That's true.
Can you set aside whatever Catholic beliefs you have regarding any issue before you?
I can. I have done that in my time on the Seventh Circuit. If I stay on the Seventh Circuit, I'll continue to do that. If I'm confirmed to the Supreme Court, I will do that still.
I would dare say that there are personal views on the Supreme Court, and nobody questions whether our liberal friends can set aside their beliefs. There's no reason to question yours, in my view. So the bottom line here is that there's a process. You fill in the blanks, whether it's about guns in Heller, abortion rights. Let's go to Citizens United. To my good friend, Senator Whitehouse, me and you are going to come closer and closer about regulating money, because I don't know what's going on out there, but I can tell you there's a lot of money being raised in this campaign. I'd like to know where the hell some of it's coming from. But that's not your problem. Citizens United says what?
Citizen United extends the protection of the First Amendment to corporations who are engaged in political speech.
So if Congress wanted to revisit that and somebody challenged it under Citizens United that Congress went too far, what would you do? How would the process work?
Well, it would be the same process I've been describing. First, somebody would have to challenge that law in a case, somebody presumably who wanted to spend the money in a political campaign. It would wind its way up, and judges would decide it after briefs and oral argument and consultation with colleagues and the process of opinion writing.
Okay. Same-sex marriage. What's the case that established same-sex marriage as the law of the land?
Obergefell.
Okay. If there was a state who tried to outlaw same-sex marriage and there's litigation, would it follow the same process?
Well, it would, and one thing I've neglected to say before that's occurring to me now is that not only would someone have to challenge that statute, and so if they outlawed same-sex marriage, there'd have to be a case challenging it, and for the Supreme Court to take it up, you'd have to have lower courts going along and saying we're going to flout Obergefell. And the most likely result would be that lower courts, who are bound by Obergefell, would shut such a lawsuit down and it wouldn't make its way up to the Supreme Court. But if it did, it would be the same process I've described.
Well, let's turn now to Senator Hawley's favorite topic, substantive due process. As a legal theory, what am I talking about? Can you explain it for the country? Because if you can't, we're in trouble. I think I'll have a hard time doing it.
So both the 14th and 5th Amendments protect life or provide that the state cannot take life, liberty, or property without due process of law. And that sounds like a procedural guarantee, but in Supreme Court precedent, it has a substantive component. And so the substantive due process clause says that there are some liberties, some rights that people possess that the state can't take away or can't take away without a really good reason. So the right to use birth control, the right to abortion are examples of rights protected by substantive due process.
These are judicially created rights not found in the document called the Constitution. Is that correct?
Well, the Supreme Court has grounded them in the Constitution.
But they're not written.
They're not expressed.
Okay. So is it fair to say there's a great debate in the law about how far this should go and what limits should apply, if any?
That's fair to say. There's also a lot of debate in Supreme Court opinions. I'm not aware of anybody proposing to throw it over entirely, but there's certainly a debate about how to define these rights and how far it should go.
Well, let's just say that you're in the camp, or anybody's in the camp, that substantive due process as a legal concept is unbounded. It basically makes the Constitution no more certain than the 5 people interpreting it at any given time in the country. Whatever rights they think you have, you get. Whatever rights they want to take away from you, they can. It's a pretty nebulous legal concept. That's sort of my view of it. I'm not imposing my views on yours. But then there's a thing called precedent. Let's say you didn't like a case decided under substantive due process. You thought the whole concept was constitutionally in error. How does precedent play?
So precedent is the principle that cases that have been decided by the court before this one lands on the docket are presumptively controlling. And so, precedent comes from a concept called stare decisis, which is a shorthand for a longer Latin phrase that means stand by the thing decided and do not disturb the calm. So precedent is a principle that you're not going to overrule something without good reason or roil up the law without justification for doing so.
So you could say the underlying analysis that led to any case, just case X, I reject that analysis, but I will now apply precedent to whether or not it should be reversed. Is that what you're telling us?
That is, because precedent is...
What are the factors would a judge look at in terms of overruling a precedent?
Well, of course, the inquiry begins because there's been some argument that the precedent was wrong. But that's not enough to justify an overruling. You also consider... You could say structurally this case should... constitutionally it was wrongly decided, but that doesn't end the debate. Is that correct? No, that's right. You have to look at reliance interest. You have to look whether the law or the facts... Let's stop right quick. Reliance interest by who? Reliance interest by those who have relied on the precedent. So the people of the United States. People of the United States who've ordered their affairs around it. So the Heller case, people have relied upon the Second Amendment being an individual right. Is that correct? Precedent, yeah, presumably so. People have... Well, abortion would be the right to have abortion. That'd be a reliance factor, right? The court in Casey spent a lot of time describing the reliance of people on the right to an abortion. So what I want the public to know is that if you overrule a precedent of the court, even if you think it was wrongly decided, there's a list of things you have to look at before you actually overrule the case. Is that a fair way of saying it? It's a fair way of saying it. Would you apply those factors if you ever found yourself in a position where you wanted to consider overruling a precedent? Absolutely. Okay. Have precedents of the court been overruled before? Yes. Can you give me an example? Brown versus the Board of Education overruled Plessy versus Ferguson to get rid of the separate but equal doctrine. Okay. So, recusal. My colleagues are asking you to recuse yourself from litigation around the Affordable Care Act. What's the precedent regarding the Affordable Care Act, if any? The precedent that might, well... Is there precedent on this issue? There's not precedent on the issue that's coming up before the court. It turns on a doctrine called severability, which was not an issue in either the two big Affordable Care Act cases. Okay, so the issue that was before the court was NFIB versus Sibelius, is that correct? That was the first, about the constitutionality of the mandate. Okay, and I think Congress has zeroed out what the court called a tax, and the real issue now is, does it stand and can it be severable? Right, so the issue now is, now that Congress has zeroed it out, can it be called a tax or is it now a penalty? And then the second issue is, if it is a penalty, can it be just cut out from the statute so that the rest of the statute, including protection for pre-existing conditions, stands? Well, a lot smarter people than me suggest that severability would be a hard challenge for those who are opposing the law, but time will tell. Do you feel like you should recuse yourself from that case because you're being nominated by President Trump? Well, Senator, recusal itself is a legal issue. You know, there's a statute, 28 U.S.C. 455, that governs when judges and justices have to recuse. There's precedent under that rule. Justice Ginsburg, in explaining the way recusal works, said that it's always up to the individual justice, but it always involves consultation with the colleagues, with the other 8 justices. So that's not a question that I could answer in the abstract. So if you're appointed by Obama, that's no reason to recuse yourself in a case involving Obama policy. Is that correct? Well, that would be a decision for each justice to make. But if a justice had a conflict with a particular policy issue, they helped draft it, that would be a consideration. Is that correct? That would be a consideration. Okay. So when it comes to recusing yourself, you'll do what the Supreme Court requires of every justice? I will. Okay. Thank you very much. How does it feel to be nominated for the Supreme Court of the United States? Well, Senator, I've tried to be on a media blackout for the sake of my mental health, but you know, you can't keep yourself walled off from everything, and I'm aware of a lot of the caricatures that are floating around. So I think what I would like to say in response to that question is that, look, I've made distinct choices. I've decided to pursue a career and have a large family. I have a multiracial family. Our faith is important to us. All of those things are true, but they are my choices. And in my personal interactions with people, I mean, I have a life brimming with people who've made different choices, and I've never tried in my personal life to impose my choices on them. And the same is true professionally. I mean, I apply the law. And Senator, I think I should say why I'm sitting in this seat in response to that question, too. Why I've agreed to be here, because I don't think it's any secret to any of you or to the American people that this is a really difficult, some might say excruciating process. And Jesse and I had a very brief amount of time to make a decision with momentous consequences for our family. We knew that our lives would be combed over for any negative detail. We knew that our faith would be caricatured. We knew our family would be attacked. And so we had to decide whether those difficulties would be worth it, because what sane person would go through that if there wasn't a benefit on the other side? And the benefit, I think, is that I'm committed to the rule of law and the role of the Supreme Court in dispensing equal justice for all. And I'm not the only person who could do this job, but I was asked, and it would be difficult for anyone. So why should I say someone else should do the difficulty? If the difficulty is the only reason to say no, I should serve my country. And my family's all in on that because they share my belief in the rule of law.
Well, thank you. I think a lot of people would say you got to be sort of insane to run for the Senate in this world. But the good news for you, we've all chosen kind of crazy stuff to do. I just end with this. I'm glad you said yes. I'm glad President Trump chose you. And really, before the people of the United States is a very basic question. Is it okay to be religiously conservative? Is it okay to be pro-life in your personal life? It clearly is okay to be progressive and be pro-choice and seek a seat on the Supreme Court. I think resoundingly yes. And here's why your nomination is so important to me. In my world, to be a young conservative woman is not an easy path to take. We have two women on this committee. They can talk about it better than I. So I want to thank President Trump for choosing you, and I will do everything I can to make sure that you have a seat at the table. And that table is the Supreme Court. And if anybody in the country, in my view, deserves to have a seat at the table based on the way they've lived their life and their capabilities in the law, it is you, Judge. God bless you. Thank you.
Thank you, Chairman Graham.
Senator Feinstein.
Mr. Chairman, Judge, it's wonderful to see you here. Also with the family that I have been observing. They sit still, quiet. You've done a very good job.
I have eyes in the back of my head, so they know I'm watching.
I was wondering if you might introduce us to them.
Sure. So I have my husband, Jesse, my son, JP, my daughter, Emma, my daughter, Juliet, my daughter, Tess, my daughter, Vivian, and my son, Liam. And then behind them are my 6 siblings who are with me today. I'll start at the side right behind Vivian. It's my sister, Vivian, my sister, Eileen, my brother, Michael, my sister, Megan, and my sister, Amanda. And is Carrie in the room? And my sister, Carrie, is sitting right over there.
You don't have a magic formula for how you do it and handle all the children and your job and your work and your thought process, which is obviously excellent, do you?
It's improv.
Yes, yes. Well, let me begin with a question that the chairman touched on. And it's of great importance, I think, because it goes to a woman's fundamental right to make the most personal decisions about their own body. And as a college student in the 1950s, I saw what happened to young women who became pregnant at a time when abortion was not legal in this country. I went to Stanford. I saw the trips to Mexico. I saw young women try to hurt themselves, and it was really deeply the most concerning. During her confirmation hearing before this committee in 1993, Ruth Bader Ginsburg was asked several questions about her views on whether the Constitution protects a woman's right to abortion. she unequivocally confirmed her view that the Constitution protects a woman's right to abortion. And she explained it like this, and I quote, "The decision whether or not to bear a child is central to a woman's life, to her well-being and dignity. It's a decision she must make for herself. When government controls that decision for her, she is being treated as less than a fully adult human responsible for her own choice," end quote. At one point, our former colleague, Orrin Hatch, then the ranking member of this committee, commended her for her being, quote, "very forthright in talking about that," end quote. So I hope, and you have been thus far, be equally forthright with your answers. In Planned Parenthood of Southeastern Pennsylvania versus Casey, Justice Scalia, as was said earlier, joined the dissent, which took the position, and I quote, "We believe that Roe was wrongly decided and that it can and should be overruled, consistent with our traditional approach to stare decisis in constitutional cases." Do you agree with Justice Scalia's view that Roe was wrongly decided?
So, Senator, I do want to be forthright and answer every question so far as I can. I think on that question, I'm going to invoke Justice Kagan's description, which I think is perfectly put. When she was in her confirmation hearing, she said that she was not going to grade precedent or give it a thumbs up or a thumbs down. And I think in an area where precedent continues to be pressed and litigated, as is true of Casey, it would be particularly, it would actually be wrong and a violation of the canons for me to do that as a sitting judge. So if I express a view on a precedent one way or another, whether I say I love it or I hate it, it signals to litigants that I might tilt one way or another in a pending case.
So on something that is really a major cause with major effect on over half of the population of this country, who are women, after all, it's distressing not to get a straight answer. So let me try again. Do you agree with Justice Scalia's view that Roe was wrongly decided?
Senator, I completely understand why you are asking the question, but again, I can't pre-commit or say, yes, I'm going in with some agenda, because I'm not. I don't have any agenda. I have no agenda to try to overrule Casey. I have an agenda to stick to the rule of law and decide cases as they come.
Well, as a person, I don't know if you'll answer this one either. Do you agree with Justice Scalia's view that Roe can and should be overturned by the Supreme Court?
Well, I think my answer is the same, because, that's a case that's litigated. It could, its contours could come up again. In fact, do come up. They came up last term before the court. So I think, what the Casey standard is, and it's a contentious issue, which is, I know, one reason why it would be comforting to you to have an answer. But I can't express views on cases or pre-commit to approaching a case any particular way.
Well, that makes it difficult for me, and I think for other women also on this committee, because this is a very important case, and it affects a lot of people, millions and millions of women, and you could be a very important vote. And I had hoped you would say, as a person, you've got a lovely family, you understand all the implications of family life. You should be very proud of that. I'm proud of you for that. But my position is a little different. You're going on the biggest court of this land with a problem out there that all women see one way or another in their life. And not all, but certainly married women do, and others too. And so the question comes, what happens? And will this justice support a law that has substantial precedent now? Would you commit yourself on whether you would or would not?
Senator, what I will commit is that I will obey all the rules of stare decisis, that if a question comes up before me about whether Casey or any other case should be overruled, that I will follow the law of stare decisis, applying it as the court has articulated it, applying all the factors, reliance, workability, being undermined by later facts and law, just all the standard factors. And I promise to do that for any issue that comes up, abortion or anything else. I'll follow the law.
Well, I think that's expected, and, I guess I've gone as far as I can. Let me go to another issue. This country is facing great gun violence. There's been a surge in gun sales during the COVID-19 crisis, which has led to more lives being needlessly lost. According to the Gun Violence Archive, an independent research organization, there were 60 mass shootings in May alone. These shootings killed 40 people. They hurt 250 more. Also, there's been a troubling spike in gun sales. Americans bought approximately 2 million guns this past March. It's the second highest month ever for gun sales. That figure does not take into account all the gun sales that could not be completed because the purchaser failed a background check, a number that has also skyrocketed. For example, this past March, the FBI's background check system blocked 23,692 sales, more than double the 9,500 sales blocked in March of 2019. Do you agree that federal, state, and local governments have a compelling interest in preventing a rise in gun violence, particularly during a pandemic?
Well, Senator, of course, the constitutionality of any particular measure that was passed by state or local governments or by this body would be subject to the same judicial process that I described with Senator Graham. What I will say, because this is just descriptive of Heller leaves room for gun regulations. And that's why there has been a lot of litigation in the lower courts, which makes me constrained not to comment on the limits of it. But Heller does not make a right absolute, says so in the opinion.
Well, let me ask one more question. In a recent dissenting opinion that you wrote, you said there was, quote, no question, end quote, that, quote, keeping guns out of the hands of those who are likely to misuse them, quote, is, quote, a very strong governmental interest. Do you stand by that statement?
So, let's see. I can't remember precisely the words of Cantor, which is the case in which I dissented, which
That's
I think
correct, Cantor v. Barr.
Cantor v. Barr. What I said in that opinion, I stand by, which is that the original meaning of the Second Amendment, and I went through a lot of detailed history in that case, does support the idea that governments are free to keep guns out of the hands of the dangerous. So, for example, the mentally ill, others who would be likely to misuse guns.
So where does that leave you on Roe? The chairman asked, I thought, a very good question. For many people, and particularly for women, this is a fundamental question. We all have our moral values, we have our religions, we live by that. I respect you and your family for doing just that. But this is a very real problem out there. And if you could be more specific in any way with respect how you would view your place on the court with respect to controlling weapons in this country.
I think what I can say is that my opinion in Cantor shows how I approach questions as a matter of judicial philosophy. I mean, I spent a lot of time in that opinion looking at the history of the Second Amendment and looking at the Supreme Court's cases. And so the way in which I would approach the review of gun regulation is in that same way, to look very carefully at the text, to look carefully at what the original meaning was. That was the method that both the majority and dissent in Heller took. So I promised that I would come to that with an open mind, applying the law as I could best determine it.
Okay, let me move on. One of my constituents, Christina Garcia, was able to obtain insurance coverage and have surgery that saved her eyesight only before the Affordable Care Act. Her experience is not unique. Senator Tammy Baldwin has a constituent, Jimmy Anderson, in her home state of Wisconsin, and she asked that this story be shared. Jimmy is a 34-year-old and member of the Wisconsin State Legislature. In 2010, a drunk driver hit the family's car as they were returning home from celebrating Jimmy's 24th birthday. Jimmy's mother, father, and little brother were killed in the accident. Jimmy was paralyzed from the waist down. His medical recovery was intense. As Jimmy has said, quote, "Doctors managed to patch me up with dozens of stitches and multiple surgeries and about a pound of steel on my spine," end quote. But soon after, his insurance company told him he was nearing his lifetime maximums and he would have to pay for the rest of his health care expenses. As Jimmy explains, quote, "With hundreds of thousands of dollars still left to go, I don't know what I was going to do. I was scared. I was terrified. I was just a student. I didn't have that kind of money." Fortunately, a few days later, the insurance company sent him another letter. This one informed him that the provisions of the ACA had kicked in, which meant there were no longer lifetime maximums and his care would be covered. In Jimmy's own words, "I was able to put my life back together, and I credit the Affordable Care Act for that." Judge Barrett, how should the loss of ACA's protection against lifetime coverage caps that can be used to end coverage for life-saving care, factor into a court's consideration of the validity of the ACA?
Senator, so far as I know, the case next week doesn't present that issue. It's not a challenge to pre-existing conditions coverage or to the lifetime maximum, relief from a cap.
Well, what is your view
of how it should factor in? Let's see. I think that any issue that would arise under the Affordable Care Act or any other statute should be determined by the law, by looking at the text of the statute, by looking at precedent, the same way that it would for anyone. And if there were policy differences or policy consequences, those are for this body. For the court, it's really a question of adhering to the law and going where the law leads and leaving the policy decisions up to you.
For me, my vote depends a lot on these responses because these are life or death questions for people. It's my understanding that you were critical of Justice Roberts for upholding the ACA, stating that he, quote, pushed the Affordable Care Act beyond its plausible meaning to save the statute, end quote. And in what way did the Chief Justice go beyond the ACA's plausible meaning?
So I've written about this, and that description is consistent with the way the Chief Justice described in his own majority. That was King versus Burwell, where the court had to decide whether the phrase established by a state also included exchanges that were established by the federal government. And the majority in that case acknowledged that treating the phrase established by a state as including exchanges established by the federal government was not the most natural reading, but for other reasons, other policy reasons and canons of interpretation, they chose to adopt the less natural reading.
You see, for me, the case coming up, California v. Texas, puts a whole new weight on your nomination. because the Affordable Care Act is now being so well accepted. I represent the largest state, as does Senator Harris, that we have. And there are just over 10 million people dependent on the activities under this act, and that they be sustained. And so there is really great concern about what your view is. That case is coming up. Can you give us at least your view?
Well, Senator, the issue in the case that's coming up doesn't involve, it's not the same issue as the ones in NFIB versus Sebelius or King versus Burwell. It's a different issue.
Well, then give us both.
Well, let's see. So what I said, what you quoted to me, was that I thought that the interpretation of the phrase established by a state was stretched when the court held that it was established by the federal government. That's not the issue in California versus Texas. The issue in California versus Texas is if whether now that Congress has just completely, zeroed out the mandate, whether it's still a tax or a penalty, and even if so, is it constitutional? And then even so, is that fatal to the statute? There's a doctrine called severability, which sounds like legalese, but what it means is it okay with the statute? Could you just pluck that part out and let the rest of the statute stand? Or is that provision, which has been zeroed out, so critical to the statute that the whole statute falls? So really the issue in the case is this doctrine of severability, and that's not something that I've ever talked about with respect to the Affordable Care Act. Honestly, I haven't written anything about severability that I know of at all.
So you have no thoughts on the subject?
Well, it's a case that's on the court's docket, and the canons of judicial conduct, would prohibit me from expressing a view.
Okay, I'll move on. On July 30th, 2020, President Trump made claims of voter fraud and suggested he wanted to delay the upcoming election. Does the Constitution give the President of the United States the authority to unilaterally delay a general election under any circumstances? Does federal law?
Well, Senator, if that question ever came before me, I would need to hear arguments from the litigants and read briefs and consult with my law clerks and talk to my colleagues and go through the opinion writing process. So, if I give off-the-cuff answers, then I would be basically a legal pundit. And I don't think we want judges to be legal pundits. I think we want judges to approach cases thoughtfully and with an open mind.
Okay, let me try something else. In 2017, in a case called EEOC v. AutoZone, the Seventh Circuit, your circuit, issued an opinion which permitted an employer to intentionally assign its employees to specific stores due to their race. The dissent in this opinion argued the decision permitted employers to legally establish separate but equal facilities, and argued, if upheld, this decision would be, quote, contrary to the position that the Supreme Court has taken in analogous equal protection cases as far back as Brown v. the Board of Education. The case was appealed to the full panel of the Seventh, and you sided, as I understand it, with the majority to deny a rehearing and let the opinion stand. Is that correct?
That is correct, and I think I need to give a little context for what it means to vote to deny, to rehear something en banc. Our court, just like the Supreme Court and the certiorari process, doesn't take cases just because we think the panel got it wrong. There's a lot of deference to panels, and Rule 35 of the Rules of Appellate Procedure constrains and limits the times in which we take the resources of the full court to rehear a case. So I was not on that panel, and I did not express a view on the merits. A vote to deny to hear something en banc is like a vote not to deny certiorari not a vote that expresses a view on the merits.
Okay.
It was a statutory case. It was not an equal protection case.
Let me ask you a question as a person.
Yes.
If an employer can transfer an employee based solely on his or her race, and that does not constitute a materially adverse employment action because it was purely lateral job transfer, please explain what factors must be present for a policy based on race to violate Brown v. the Board's prohibition of separate but equal.
Well, Senator, to my knowledge, Brown wasn't at issue in the majority opinion. It turned on statutory language in Title VII. But again, I didn't express a view on the merits, and so I can't comment on whether I think that the panel majority got that right or got that wrong. You know, that's an issue that may well come before me, even in the Seventh Circuit. Some may press for its overruling, and I may be on a panel that has to decide whether that precedent was wrong.
Well, let me ask you, as a person, do you have a general belief?
As a person, I have a general belief that racism is abhorrent.
That racism is what?
Abhorrent.
Well, I think I think we would all agree with that. So how should a lower court in the Seventh determine when race-based policies could constitute a materially adverse employment action?
Well, I'm not aware of cases presenting the exact same facts as that.
Just asking you for your view.
You know, I know that the material adverse consequence was the standard at issue in that case. I have to confess that I would need to look at the statute and the precedent to, well, even if I had a specific hypothetical in front of me, I couldn't really say without looking at the statute and the precedent what factors are involved, because I wasn't on that panel and haven't decided a similar case.
Okay, let me go to another issue. The issue of LGBT equality is very personal for me. I spent 2 decades as a county supervisor and mayor of a city. I watched firsthand as the LGBT community fought for legal recognition of their lives, their relationships, their personal dignity. I was there before the law, so I saw in San Francisco what was happening. I want to speak briefly about one couple, Del Martin and Phyllis Lyon, who I met in the 1970s. They were vibrant members of San Francisco's community. I was president of the Board of Supervisors. They worked with me to pass a citywide ordinance in 1978 that provided critical protection against discrimination in employment, housing, and public accommodations. At that time, this was one of the strongest protections for the gay community in the entire nation. We've come a long way since then, and I think we should never go back. In June of 2008, 58 years after they met, my 2 friends were finally able to marry when the California Supreme Court ruled that same-sex couples cannot be denied the fundamental right to marry. Del died 2 months later. Because of the Federal Defense of Marriage Act, DOMA, Phyllis was denied Social Security survivor benefits, even though her spouse had paid into this basic safety net for her entire working life. Phil had to rely on the help of friends and fellow activists. In 2013, as you probably know, because you know so much about this, U.S. v. Windsor, the Supreme Court struck DOMA down. 2 years later, in Obergefell v. Hodges, the Supreme Court recognized that the fundamental right to marry could not be denied to LGBT Americans. Both decisions were decided by a 5-4 margin. Justice Ginsburg was in the majority. Justice Scalia dissented in both cases. Now, you said in your acceptance speech for this nomination that Justice Scalia's philosophy is your philosophy. Do you agree with this particular point of Justice Scalia's view that the U.S. Constitution does not afford gay people the fundamental right to marry?
Senator Feinstein, as I said to Senator Graham at the outset, if I were confirmed, you would be getting Justice Barrett, not Justice Scalia. So I don't think that anybody should assume that just because Justice Scalia decided a decision a certain way, that I would too. But I'm not going to express a view on whether I agree or disagree with Justice Scalia for the same reasons that I've been giving. You know, Justice Ginsburg, with her characteristic pithiness, used this to describe how a nominee should comport herself at a hearing. No hints, no previews, no forecasts. That had been the practice of nominees before her, but everybody calls it the Ginsburg rule because she stated it so concisely, and it's been the practice of every nominee since. So I can't, and I'm sorry to not be able to embrace or disavow Justice Scalia's position, but I really can't do that on any point of law.
Well, that's really too bad because it's rather a fundamental point for large numbers of people, I think, in this country. I understand you don't want to answer these questions directly, but you identify yourself with a justice that you, like him, would be a consistent vote to roll back hard-fought freedoms and protections for the LGBT community. And what I was hoping you would say is that this would be a point of difference where those freedoms would be respected. And you haven't said that.
Senator, I have no agenda, and I do want to be clear that I have never discriminated on the basis of sexual preference and would not ever discriminate on the basis of sexual preference. You know, like racism, I think discrimination is abhorrent. On the questions of law, however, because I'm a sitting judge and because you can't answer questions without going through the judicial process, can't give answers to those very specific questions.
Okay. Thank you very much. Thanks, Mr. Chairman.
Thank you, Senator Feinstein. Senator Grassley.
Yeah. Judge, welcome you again. And you can rest for a minute because I've got some things to say to my colleagues, but more importantly, so people around the country understand what's going on here. First of all, for your family and friends, I'm sure they're very proud and they ought to be. I think everybody recognizes your sharp intellect, a deep understanding of, and even great reverence for the Constitution. Your legal experience and public service are impressive. Your dedication to mentoring young students and women in the legal profession ought to be admired by everybody. In all respects, you're exceptionally qualified to be a justice. Many groups and individuals have written in strong support, so I guess now that the chairman's gone, I'm going to ask, as the next one ranking, I got some letters from 21 state lieutenant governors and from 20 secretaries of state that I want to put in the record at this point. Before I question, I have a few points to make. Yesterday, my Democrat colleagues spoke about their concern that you, Judge, wouldn't uphold certain laws, including the Affordable Care Act, and that you would strip Americans of their health care rights and those protections that come with it. These opponents said that Republicans just want to confirm you so that you, quote, will carry their policies forward, meaning Republican policies forward on the Supreme Court. But this only shows Democrats fundamentally misunderstand what judges are supposed to do. A judge is supposed to interpret laws in an impartial manner, consistent with the Constitution. Republicans aren't interested in seeing judges, quote unquote, carry their policies forward. Republicans want judges to interpret the law and the Constitution, not make law. We want judges that won't impose their policies and personal preferences in their decision making. Plain and simple. Policy making is not the proper role of the judicial branch. That role is reserved for legislative and executive branches. As the judge said, the political branches, elected by and accountable to the people, because you got a lifetime appointment. And if you do lawmaking, we can't vote you out of office. Lawmaking's our job. If people don't like what we do, they can vote us out of office. Some other points on the Affordable Care Act. The Democrats continue to misrepresent or claim to know Barrett's view on affordable care and access to health care. In fact, they made it their entire game plan yesterday, and I suppose today we'll see it again. But we should dispense with the total fiction the Democrats are peddling. Apparently, her technical concerns with Chief Justice Roberts' legal reasoning in the Obama decision disqualifies her. Democrats are painting the judge as heartless and on a mission to scrap the health care law. Frankly, that's absurd. Not only is Judge Barrett a mother of 7, she has children with pre-existing medical challenges of her own. No one on this committee or anyone has any right to suggest that she doesn't care about access to health care or protection for the vulnerable. Now, getting back to the technical concerns about Roberts' Affordable Care Act opinion, first, and I got 4 points along this line, her comments dealt with Roberts' statutory interpretation of just one provision of the law. That provision is no longer even in effect. In 2017, Congress zeroed out the so-called tax, the tax connected with the individual mandate. The question before the court this fall are entirely separate. She never ruled on the Affordable Care Act, nor commented on how she'd vote, meaning the judge, how she would vote. So it's pointless to speculate, but we're going to get a lot of speculation during this election season, just 2.5 weeks before the election. Now, second point, lawyers and legal academics often consider a court reasoning even when they have no disagreement with the outcome of the case. For instance, the New York Times recently reported Ginsburg, before joining the Supreme Court, quote, wasn't really fond of Roe v. Wade. She didn't like how it was structured, end of quote. I don't blame or don't know why Democrats have a different standard for you, Judge Barrett. Now, a third point. It's blatantly inconsistent for the left to use this line of attack. We all know that President Obama said that the ACA legislative mandate was not a tax. Even liberal Jeffrey Toobin said Roberts' argument was, quote, not a persuasive one, end of quote. So Judge Barrett's analysis of Roberts' legal reasoning is well inside the mainstream. Now a fourth point, more inconsistency. The same Democrats vilify Judge Barrett as a threat to those with pre-existing conditions. Well, it seems that those same people just filibustered the COVID relief bill that would have protected pre-existing conditions. They're the ones that blocked the COVID relief legislation. Republicans stood ready to move forward with that bill and remain ready. Seems to me it's the other side who really playing politics with health care during a pandemic. The truth is, Judge Barrett already said, quote, a judge must apply the law as written, end of quote. She further commented, quote, to decide cases according to the rule of law, beginning to end of quote. That's what we should all look for judges to do. Now, for my first question. when Justice Scalia came to my office before his confirmation, and I think I brought this up with every nominee to the Supreme Court by Republican or Democrat nominees. I don't think I brought it up in my private conversation with you, but I always bring up, what's your attitude about legislative history? No, let me ask my
sorry.
question first. I'm sorry.
I thought that was it.
I think you probably know, Judge, how important it is. I want to know how important legislative history is to you. When is it appropriate to look to legislative history to interpret the statute? And are there some circumstances when more appropriate than other? And I'd like to also give your view on legislative history compared to what I heard from Scalia 35 years ago.
Sure. So I'm very comfortable talking about the use of legislative history because that's a matter of interpretive philosophy. What governs, of course, is the text of the statute. So, the legislative history can never supersede the text, and it should never substitute for the text of the statute. Justice Scalia, as was well known, railed against the use of legislative history. And I think it was because at the time that Justice Scalia went on to the D.C. Circuit, before he was on the Supreme Court, the use of legislative history had really kind of gotten out of control. And many courts, were saying things. Justice Scalia in his book quotes this line from a brief, the legislative history being unclear, we turn to that other reliable guide in statutory interpretation, the statute. And that has things backwards. And so I think Justice Scalia really tried to clean that up and say, listen, the priority is the text. And when the text answers the question, you don't go to legislative history. And there's some pragmatic reasons to be careful about doing so. Legislative history can be long. There's a famous quotation from Judge Leventhal that legislative history is like going to a cocktail party and picking out your friends. It can be easy to manipulate because there might be something in there for everyone. So as a general rule, I don't look to legislative history when I'm deciding cases. I wouldn't say that it would never be relevant. Even Justice Scalia himself said that there could be instances, for example, if you were trying to determine whether a term used in a statute, how it was used, if it had a technical meaning or how it was understood, that might be an appropriate time to consult legislative history. Or Justice Scalia himself consulted it when he was trying to determine whether there had been an error in the way the statute was drafted. He looked to legislative history to see whether what seemed unthinkable actually was unthinkable.
Now I'd like to go to a specific case. I'd like to go to United States versus Urarte, which involved the interpretation of Section 403 of the First Step Act, which I had a big part along with Senator Lee and Senator Durbin in getting that passed in 2018. This is the most significant criminal justice legislation in a generation. Our criminal justice system can't just punish and deter. It must also rehabilitate and promote successful reentry into society. The First Step Act accomplished these goals through prison and sentencing reform. It was well known that the goal of the First Step Act was to make smart and cost-effective changes to the criminal code and to reduce risk of recidivism. So I want to ask you about your dissent in this case. The issue was whether the sentencing reform provision of the First Step Act applied to a defendant whose sentence had been vacated. Here, the defendant had been convicted but not resentenced at the time of the First Step Act becoming law. The majority opinion cited the plain meaning of the First Step Act and congressional intent in finding that Section 403 would apply to a defendant with a vacated sentence. Your dissent, as I understand it, argued, among other things, that congressional intent shouldn't be heavily relied on since, quote, every statute requires a resolution of competing policy interests, end of quote. President Trump signed the First Step Act into law only 2 years ago, so wouldn't re-referencing congressional intent be accessible and relevant? And then another question, why did you find the majority relying on legislative history unpersuasive?
So we did, the majority. It was a very, very difficult case. It was voted on en banc by our full court. And the quote from my dissent that you're pointing to was actually that we had a dispute about what the plain text of the statute required. And so that portion of my dissent that you just read was saying that I thought that the majority had permitted the policy goals of the act to supersede the text. And in dissent, I argued that the text drew the line after someone had been sentenced. So if someone had already been sentenced on the date of the First Step Act's passage, and the relevant language was, if a sentence had already been imposed, I thought with my dissenting colleagues, and this was consistent with the approach the Third Circuit had already taken, that meant if the person had already been through sentencing. In this case involved a resentencing. And resentencing can happen years after, and so it didn't seem to my dissenting colleagues and I that looking in the statute that the plain language of the text supported the majority's approach to it.
Now, I think on my next question on the same case, you may have just partially answered it, but let me go ahead with my lead in and then also a question. Both the majority and your dissent in the case reviewed 403 of the Act under a plain reading of the text. As an author and leader in this law's passage, I'd like to discuss how a plain reading of the statute could lead to varying outcomes. The section in question contemplates when a sentence has been imposed on a defendant. According to the text of the statute and relevant case law, a defendant's sentence, if vacated, creates a clean slate. That means defendant is placed in the same position as if he had never been sentenced. But your dissent comes to the opposite conclusion on whether a sentence has been imposed. Note that I agree with you that the laws need to be read and interpreted literally. So my question is this: how could we come to different conclusions?
Well, that language, that it did not apply to defendants on whom sentences had already been imposed. My dissenting colleagues and I said, well, the language is sentences. It doesn't say, invalid sentences. And one could certainly say, if asked if someone had been sentenced, yes, he was sentenced, but that sentence was later vacated. And you're right that the majority relied heavily on this clean slate principle, but in my review of the law, this clean slate principle wasn't really present because, the Sentencing Reform Act, for example, instructs district courts applying the guidelines at sentencing to apply those that were in effect on the date of the original sentencing. So I thought that the clean slate principle, they were pushing a little too hard on it. And then, there's certainly unfairness. The First Step Act, its policy is clearly to bring justice to sentencing. But whenever you draw a line and who gets the benefit of a law, and this is especially acutely true in the sentencing area, it's very difficult. And, some people right on either side of the line will not get the benefit of the law wherever you draw it. So, for example, in this case, Mr. Uriarte had a co-defendant named Sparkman. His case came up right behind together. They had been tried together and initially sentenced together. But Uriarte's appeal took longer to resolve, or his resentencing took longer because of a lot of delays. So there was unfairness there, too, in the majority's approach, because Uriarte, despite the fact that he was more culpable than Sparkman, wound up with a sentence that was like 15 years less.
That's the end of my questioning on that, but let me make a comment before I go to my next question. My position has always been that legislative history can be instructive with respect to the intent of the statute, so judges should not completely disregard it. Certainly, I acknowledge that the legislative branch can be more careful about drafting laws, but I also think that judges should pay attention to congressional intent as set forth in history when there might be a dispute about how to interpret the statute. Justice Ginsburg, at her hearing, quote, and you've discussed this a little bit already, but I think it deserves emphasis because you're going to go through a lot of this business of maybe not being, and I know legitimately not being able to comment on a prospective case. So she said, quote, "A judge sworn to decide impartiality can offer no forecast, no hints for what would show not only disregard for the specifics of this particular case, it would display disdain for the entire judicial process." Obviously, we all know, end of quote, we all know that that's the Ginsburg standard. The underlying reason for this rule is that making promises or giving hints on how a judge would rule in a case undermines the very independence of our system. But you're going to be asked about your personal views, as you just have been, on various topics, and how you might correctly decide. Of course, you know the judicial nominees should never promise their future votes on the bench in exchange for the president's nomination or a senator's support. You'd be showing the opposite of independence. So my question, so I ask you, do you agree with the Ginsburg standard that it goes to the question of judicial branch's independence for legislative history? And all you got to do is say yes, because I've heard you talk about it.
Yes, I agree. The Ginsburg rule reinforces judicial independence.
Yeah. Now, here's something that a lot of people suspicion, so I want to ask you. Have you made any promises or guarantees to anyone about how you might rule on a case or issue that might come before you if you're confirmed to the Supreme Court?
I want to be very, very clear about this, Senator Grassley. The answer is no, and I submitted a questionnaire to this committee in which I said no. No one ever talked about any case with me. No one on the executive branch side of it. And that's one reason you asked that question, I think, as a committee, is that you want to know that no nominee has made any pre-commitments. Yeah. And so just as I didn't make any pre-commitments and was not asked to make any commitments on the executive branch side, I can't make any pre-commitments to this body either. It would be inconsistent with judicial independence.
Now, I know the answer to my last question, and Mr. Chairman, I'm going to reserve the rest of my time. The Democrats claim that you're being put on the Supreme Court so you can vote to repeal the Affordable Care Act. Is that your agenda? If confirmed, is your goal repealing the Affordable Care Act? Have you committed to the President or anyone else that you will vote to repeal the Affordable Care Act if confirmed by to the court?
Absolutely not. I was never asked, and if I had been, that would have been a short conversation.
I think that your record shows that you'll be a faithful judge that takes each case seriously and approach each case in an unbiased way rather than with the policy agenda in mind. Is it fair? We can reserve our time.
Absolutely.
Okay.
Senator Leahy,
Letters for the record.
I'll introduce the letters by Senator Feinstein will be introduced into the record without objection. Senator Leahy, are you with us?
I think I am. Do you hear me there?
Yes, sir. See if we can get you up on the screen here. There you go. Floor is yours.
Thank you. Thank you very much. And Judge, I was watching as you introduced your family. Thank you for doing that. It's obvious your family is very important to you, as they should be. I know my wife and I have been married for 58 years, and our children and our grandchildren are the most important things in our life. And I was pleased to see you and to introduce the family. Now, as a senator, of course, another important part of my life is referring to and representing the people of Vermont. And let me talk to you about some of the things I've been hearing from Vermonters. And you have to understand, in Vermont, Vermonters just walk up to you at the grocery store or coming out of church or whatever and perfectly happy to express their views. And they're concerned about what the Republicans' Affordable Care Act lawsuit on November 10th would mean for them. Now, do you know how many Americans have obtained insurance through the Affordable Care Act?
I do not.
It's more than 20 million. And do you know how many children under the age of 26 are able to stay on their parents' insurance because of the Affordable Care Act?
I do not.
It's 2.3 million. And do you know how many Americans are covered under the Affordable Care Act's Medicaid expansion?
I do not.
It's a little more than 15 million. And I look at that because I look at the people called me from Vermont. I think of Alex Johnson. She's a single mother. She's a childhood cancer survivor. She works as a nanny in South Burlington, Vermont. She relies on Medicaid for her doctor's visits or blood drawings or other testing. All that done to make sure her leukemia stays in remission. She tells me she stays awake at night worrying about losing Medicaid. Now, if the Republicans are successful in what they're trying to do on November 10th, then Alex and actually 60,600 other Vermonters enrolled in Medicaid expansion are going to be left behind. And you contract COVID-19, that's seen as a pre-existing condition. Do you know approximately how many million Americans have tested positive for the coronavirus and survived?
I do not.
That's more than 7,700,000. Those are people now considered to have a existing condition. And one of the most common pre-existing conditions is diabetes. The CDC estimates that 34 million Americans, that's about 1 in 10 Americans, have diabetes. They show that the ACA's Medicaid expansion is the single most important factor for expanding access to affordable insulin. Leslie, a Vermonter diagnosed with late onset type 1 diabetes at the age of 25. For years, she has depended on Medicaid to keep her alive and out of bankruptcy. Now, President Trump recently claimed that he's made insulin as cheap as water. I wish he had told the truth on that. We all know it's not. Leslie now has insurance to pay for insulin. And without this insurance, do you know how much? Because unlike what the president says, insulin is not as cheap as water. Do you have an idea how much Leslie's out-of-pocket expenses for insulin would increase?
No, I do not.
Thank you. And I wouldn't expect you to. There's no reason why you should, but Leslie's costs would more than triple. It'd go up by $11,215 a year. That's in a state where the per capita income is $33,000. So I'm not suggesting that you're callous or indifferent to the consequences if the Affordable Care Act is overturned. You know these are real cases, and I think you're a sympathetic person. But I do believe that the president selected you because he wanted somebody with your philosophy, and he had a reason for it. Now, some are going to pretend that it's a mystery, and that's what some of my colleagues have. What a Justice Barrett would do when the Supreme Court takes up the latest attack on the ACA. President Trump has made it crystal clear. He's promised that his nominees would overturn the ACA. It's even in the official Republican Party platform. And when he said of the case to be argued next month, he said, we want to terminate health care under Obamacare, the ACA. And within hours of nominating you, he again repeated his hope that the ACA would be overturned. I know I mentioned my friend, the chairman, Senator Graham, knows the president as well as anyone here. He goes golfing with him. He spends a lot of time with him. And I think Chairman Graham knows that the president would not repeatedly promise the American people that his judges would overturn the ACA if he didn't mean it. And I think Senator Graham would have to agree that the president's confident Judge Barrett would side with him on November 10th. That's not necessarily a question for either one of you, but of course the chairman has an opportunity to respond on his time if he wants. But I think we know the president's confident. There's not been an issue in the last decade that's animated Republicans in Congress more in their zeal to overturn the Affordable Care Act. In fact, I counted up the other day, I was surprised at the answers. You know, Judge Barrett, that Republicans in Congress have voted to repeal or gut the ACA more than 70 times, 70 times in the last 10 years. And when they failed, they turned to the court. Do you know how many Republicans on this committee have joined amicus briefs urging courts to overturn the ACA in NFIB versus Sebelius and King versus Burwell?
How many Republicans had voted? Was that the question?
No. Do you know how many Republicans in this committee have joined in amicus briefs urging the courts to overturn the ACA?
I don't. I'm having a little bit of trouble hearing Senator Leahy. Is there a way for the volume to be turned up?
Yes, ma'am.
I am sorry for that.
It's on our end, Senator Leahy. That's okay. You can repeat the question and.
Well, how is it coming through now?
Very good.
Very well, thank you.
Well, and as you know, I've stayed away simply because I don't think it is safe for you or anybody else to be there. But my question is, do you know how many times Republicans on the committee you're sitting before have joined amicus briefs urging courts to overturn the Affordable Care Act?
I do not know.
It's at least 9 by my count. In fact, they've already weighed in on the November 10 case. 2 weeks ago, the Senate voted on whether to side with President Trump in Texas versus California. And 11 of the 12 senators on this committee sided with the Trump administration and asked to kill the ACA. Now, I understand that you will not share your views on Texas versus California. I know you look at Judicial Canon 3A6 and you're concerned that commenting may give future litigants that appear before you an indication of which way you would rule. Is that correct?
Yes, that is correct.
Okay. Now, my concern my concern is that you've already given us every indication. Every time you weighed in, it hasn't even been close. You've repeatedly disagreed with Chief Justice Roberts. What you said, you clearly believe the statute is unconstitutional. The president has made very clear he expects you to side with him. And let me tell you another area where he expects you to side with him. He expects you to side with him in an election dispute. He says he needs a ninth justice because he's counting on the court to look at the ballots. He says the election will be rigged. The recusal statute, 28 U.S.C. 455, requires recusal where impartiality might reasonably be questioned. Now, when the president declares he needs his nominee to secure his reelection, and then the nominee is ran through the Senate in record time during the middle of an election, some are going to question that nominee's impartiality. Would you, to protect confidence in both you and the court, would you commit to recuse yourself from any dispute that arises out of the 2020 presidential election.
Senator Leahy, I want to begin by making two very important points, and they have to do with the ACA and with any election dispute that may or may not arise. I have had no conversation with the president or any of his staff on how I might rule in that case. It would be a gross violation of judicial independence for me to make any such commitment or for me to be asked about that case and how I would rule. I also think it would be a complete violation of the independence of the judiciary for anyone to put a justice on the court as a means of obtaining a particular result. And that's why, as I was mentioning, I think to Senator Grassley, that the questionnaire that I fill out for this committee makes clear that I have made no pre-commitments to anyone about how I would decide a case. That's out of respect for Article 3 and its designation of the judiciary as a co-equal and independent branch of government. On the recusal question.
I might say that you gave a similar answer when I talked with you and Mr. Cipriani. I had a question, of course, because one of the members of our of the Judiciary Committee said that he would not support you unless he had a commitment that you would vote that way.
Vote on the election?
On another case, Roe versus Wade. And I understand what you're saying is notwithstanding what a member of this committee said, you have not made that commitment to anybody. Is that correct?
Senator Leahy, let me be clear. I have made no commitment to anyone, not in this Senate, not over at the White House, about how I would decide any case.
Well, and the reason I ask is we also have the question of appearance. Now, Judge Joan Larson of the Sixth Circuit sat next to you during your 2017 hearing. She was confronted with this issue as a judge on the Michigan Supreme Court in 2016. Then President-elect Trump challenged a ballot recount. Judge Larson was on his short list for the Supreme Court at the time. She found that being on the short list was a conflict and it required her recusal. You were also on the short list, and then you were actually chosen. Now he's not the president-elect, he's the president. And then the president makes a similar thing as he did, and the Judge Larson looked at. He's counting on you to deliver him the election. Judge Larson said that was a conflict for her and would have to recuse. You do not find his comments a conflict for you, is that correct?
Senator Leahy, I'm not familiar with Judge Larson's decision, but she clearly made it once it was presented to her in the context of an actual case where she had to weigh her obligations under 28 U.S.C. 455. If presented to me, I would, like Judge Larson, apply that statute. And I recently read a description by Justice Ginsburg of the process that Supreme Court justices go through in deciding whether to recuse. And it involves not only reading the statute, looking at the precedent, consulting counsel if necessary, but the crucial last step is that while it is always the decision of an individual justice, it always happens after consultation with the full court. So I can't offer an opinion on recusal without short-circuiting that entire process.
Well, I think that what I worry about, and I've said over and over again, that if the courts are politicized, from the Supreme Court down through other courts, and I've argued cases in all levels of our federal courts, I've always assumed the judges are totally impartial no matter what president had nominated them. But this president has not been subtle, and they expect his nominee to side with him in an election dispute. I'm thinking of the credibility of our federal courts, and I hope you would at least consider that. The president said he needs a ninth justice because he's counting on the court to look at the ballots in case he loses, because that if he lost, that meant the Democrats had rigged the election. the recusal statute, as you know as well as anyone, 28 U.S.C. 455 requires a justice recuse herself in any proceeding in which impartiality might reasonably be questioned. Now, whether you like it or not, and I suspect you probably do not, the president has placed both you and the Supreme Court in the worst of positions. And so let me ask you a different type of question. I assume you agree with me that it's critical for Americans to have confidence in the Supreme Court. Is that true?
That is true. And I agree with your earlier statement that the courts should not be politicized.
Thank you. And I voted for an awful lot of Republican and Democratic nominated justices, as I did, of course, for Chief Justice Roberts, because I wanted to keep Supreme Court and other courts out of politics. But when the president repeatedly declares he needs his nominee as a way of securing his reelection, and that nominee is then rammed through the Senate in the middle of that election, well, you can see where the nominee's impartiality might be questioned. So my request is, in protecting confidence in both you and the court, are you able to commit to recuse yourself from disputes that arise out of the 2020 presidential election?
Senator Leahy, I commit to you to fully and faithfully applying the law of recusal, and part of that law is to consider any appearance questions, and I will apply the factors that other justices have before me in determining whether the circumstances require my recusal or not. But I can't offer a legal conclusion right now about the outcome of the decision I would reach.
Which is sort of boilerplate response on recusal. So let me ask you another question. You laid out the case for blocking President Obama's Supreme Court nominee, Judge Merrick Garland, for 10 months during election year. You argued in part that Justice Scalia was the staunchest conservative on the court, and Justice Scalia and I were personal friends. I'd voted for him, and I agree with you on that. You claim that the moderate and eminently qualified Judge Garland would dramatically flip the balance of the court. You said it was not a lateral move. That's your quote. It was not a lateral move. So now you're nominated to replace Justice Ginsburg, perhaps the staunchest champion for civil rights of the court. You claim that philosophy of Justice Scalia is your own. Of course, he was the opposite side of Justice Ginsburg in countless civil rights cases. Would you say that replacing Justice Ginsburg by yourself is not a lateral move, like you had urged when you supported the blocking of President Obama's nominee, Judge Garland?
Senator Leahy, I want to be very clear. I think that's not quite what I said in the interview. It was an interview that I gave shortly after Justice Scalia's death. And at that time, both sides of the aisle were arguing that precedent supported their decision. And I said, while I had not done the research myself, my understanding of the statistics was that neither side could claim precedent, that this was a decision that was the political branches to make. And I didn't say which way they should go. I simply said it was the Senate's call. I didn't advocate or publicly support the blockade of Judge Garland's nomination, as you're suggesting.
That's not what I'm suggesting. You said it was a lateral. It would not be a lateral move.
What I was suggesting is that it was unsurprising that there was resistance as a political matter to that nomination because it would change the surprised. I was surprised there was resistance insofar as there's so many, at that time, Republican members of the Judiciary Committee who had stated publicly before
the vacancy, they thought Merrick Garland would be a good person to have on the court, and somebody could appeal to both conservatives, liberals, and moderates. But
I have
I
full
think
respect for Judge Garland.
I beg your pardon?
I'm sorry, I missed the
That's
first
it.
part. Are they right to say, could you repeat the question?
No, it's not a question. I was just saying that we had many members of our committee, a number of Republicans who prior to the vacancy had been saying Merrick Garland would be a good person for President Obama to nominate because he could appeal to moderates, conservatives, and liberals. And then of course, their response was, well, we can't have a nominee confirmed by one party that's in control of the Senate and nominated by a president of another party. Of course, I pointed out I was here when Democrats controlled the Senate, and President Reagan nominated Anthony Kennedy, and in an election year, Democrats confirmed him. But let me go to another area. Three-judge panel of the Seventh Circuit struck down 3 provisions of an Indiana law restricting reproductive rights. The state of Indiana requested en banc review of just one of the provisions, the fetal tissue disposition provision. Court split on whether to review the case, leaving intact the panel decision striking down the law. You joined Judge Easterbrook in his dissent. But then the dissent went out of its way to address a separate provision not before the court, the so-called reason ban. Your dissent called a eugenics statute. Judge Barrett, the issue before your court was a narrow one. Why didn't you limit your dissent to the one issue the state of Indiana was asking you to review?
So we dissenters from that denial of rehearing en banc, first of all, dissented, as you say, on the fetal remains disposition portion, which the Supreme Court wound up summarily reversing the panel. On the eugenics portion of the bill, it is true that the state of Indiana did not seek en banc rehearing on that, but we had many other states enter the case as amici, urging us to take that claim up. And what Judge Easterbrook's dissent did was explain why he actually thought it was an open question, but one best left to the Supreme Court. And we didn't reach any conclusion with respect to it.
Well, and your whatever position you took would not have changed the final decision of the court. Now, in 2006, you signed an open letter that's published in the South Bend Tribune. You, on one side, the advertisement describes the legacy of Roe versus Wade as barbaric. On the other side, what you signed, you stated that you oppose abortion on demand, defend the right to life from fertilization to natural death. And I have certainly voted for some judges to take that position. But while not mentioned in the letter, the organization that led the effort believes that in vitro fertilization, IVF, is equivalent to manslaughter and should be prosecuted. Do you agree with them that IVF is tantamount to manslaughter?
Senator, the statement that I signed, as you said, simply said, I signed it on the way out of church. It was consistent with the views of my church, and it simply said, we support the right to life from conception to natural death. It took no position on IVF.
No, I understand that. And as I said, I voted for judges who take the same position you do. But I'm asking, do you agree with the St. Joseph County Right to Life that sponsored the ad that IVF is tantamount to manslaughter?
Well, Senator, I signed the statement that you and I have just discussed, and you're right that the St. Joseph County Right to Life ran an ad on the next page, but I don't even think the IVF view that you're expressing was on that page, but regardless, I've never expressed a view on it, and for the reasons that I've already stated, I can't take policy positions or express my personal views before the committee. Because my personal views don't have anything to do with how I would decide cases, and I don't want anybody to be unclear about that.
Let me talk about some of the positions you have taken. Before you became a judge, you were paid by the Alliance Defending Freedom, ADF, for 5 lectures. You gave them on originalism at the Blackstone Legal Fellowship. Now, I recall being asked about some of their controversies. Were you aware of ADF's decades-long efforts to recriminalize homosexuality?
I am not aware of those efforts, no.
Okay, one of the reading materials they had for the program that you lectured to several times spoke of that. In fact, they had filed a brief in Lawrence versus Texas in support of state laws punishing private homosexual activity. They celebrated when India restored a law punishing sodomy to 10 years in prison. Now, whether you believe that being gay is right or wrong is irrelevant to me. But my concern is you work with an organization working to criminalize people for loving a person that they are in love with. So that's what worried me.
Did you? I wasn't sure if you wanted me to answer that.
Go ahead. Go ahead.
My experience with the Blackstone program at which I spoke was a wonderful one. It gathers, best and brightest Christian law students from around the country. And as you said, I gave a 1-hour lecture on originalism. I didn't read all of the material that the students were given to read. That had nothing to do with my lecture. I enjoyed teaching the students about what my specialty was, which is constitutional law, and nothing about any of my interactions with anyone involved in the Blackstone program were ever indicative of any kind of discrimination on the basis of anything.
Well, as you know, same-sex marriage, for example, and Senator Feinstein mentioned this at the beginning, is legal, certainly legal in my state, has been for some time. Do you feel that should be a crime?
Same-sex marriage?
Yes.
Obergefell clearly says that there is a constitutional right to same-sex marriage.
And do you agree with that, stare decisis?
Well, Senator, for the reasons that I've already said, I'm not going to, as Justice Kagan put it, give a thumbs up or thumbs down to any particular precedent. It's precedent of the Supreme Court that gives same-sex couples the right to marry.
Well, you mentioned Justice Kagan. She once wrote an opinion that it's not enough that 5 justices believe a precedent is wrong. Reversing course demands a special justification over and above the belief that the precedent was wrongly decided. Do you agree with that?
I do agree with that. The doctrine of stare decisis itself requires that.
You, having relied on stare decisis in many of my arguments before courts of appeals, I thank you for your answer. Chief Justice Roberts.
Senator Leahy, I don't mean to interrupt. I know you don't have a clock in front of you, but we're about a little over a minute over. So if
I'm sorry, Mr. Chairman, I do not have a clock.
No, I understand. I totally understand.
I appreciate it, and I will look forward to the next round of questioning.
Thank you. We'll make
Thank
sure
you.
that happens. Very briefly, before I go to Senator Cornyn, Senator Leahy mentioned my time with the president. I think probably all of us on this side were consulted by the president regarding how to fill the opening. He gave me a small list of names, all women. You were on it. I was enthusiastic about everybody and very enthusiastic about your nomination by the president. Play a lot of golf with the president, I guess. I've enjoyed it. We talk about a lot on the golf course, some policy. Killing Soleimani, we talked about that. That was an interesting discussion. I promise you, I've never talked about severability with the president. Senator Cornyn.
Speak for yourself. Good morning, Your Honor.
Good morning, Senator Cornyn.
You know, most of us have multiple notebooks and notes and books and things like that in front of us. Can you hold up what you've been referring to in answering our questions? Is there anything on it?
That letterhead that says United States Senate.
That's impressive. Well, Judge, the best I can understand, the objections to your nomination are not to your qualifications, your experience, or training, but it's that you have or you will violate your oath of office. I find that terribly insulting. They suggest that you can't be unbiased in deciding a case you haven't even participated in yet. I find that insulting as well. You know, almost as pernicious as attacking somebody for their faith and suggesting that that disqualifies them from holding a public office is the attack that's being made on judicial independence, something that Chief Justice Rehnquist, among others, observed are the crown jewels of the American Constitution and the American system. But I want to just take a little walk down memory lane here. You know, there are a lot of people who guessed how judges would actually rule on cases, and almost always they've been spectacularly wrong. I was struck by just a couple. Harry Truman said, whenever you put a man, and that he's talking about a man, but a man or woman on the Supreme Court, he ceases to be your friend. He said some more colorful things, too. But Theodore Roosevelt said about Oliver Wendell Holmes Jr., he said, I could carve out of a banana a judge with more backbone than that. And as I think about people like Harry Blackmun, nominated by Richard Nixon, who wrote Roe versus Wade. As I think about Warren Burger, you know, they were called the Minnesota Twins, and obviously over time they became sort of polar opposites on the court. I think about the attacks on Neil Gorsuch for his unwillingness to make a prior commitment on LGBT issues. He wrote the Bostock case extending Title VII of the Civil Rights Act to gay or transgender individuals. Obviously, those predictions were wrong. And then, since we're talking about the ACA, it's the ACA versus ACB, I guess. Chief Justice Roberts was the one who wrote the opinion upholding the Affordable Care Act, as you know. So I would just say that all of these predictions about how judges under our independent judiciary will make decisions are just pure speculation. But I think they're worse than speculation. I think they're propaganda in order to try to make a political point. So, Judge, you're not willing to make a deal.
No, Senator Cornyn, I'm not willing to make a deal, not with the committee, not with the president, not with anyone. I'm independent.
I just would like to hear maybe some of your thoughts on, in the Oberfell case, which established, as you said, a constitutional right to same-sex marriage, part of that decision struck down the Defense of Marriage Act, correct?
Yes, I believe so.
That was a bill that Joe Biden voted for?
I don't know
Well,
about that.
I do.
Okay.
Joe Biden voted for it, Pat Leahy, and Bill Clinton signed it into law. Can you just, I'm not asking you to get into the details, but just sort of differentiate for everybody listening what the approach of a legislator is in voting for a piece of legislation as opposed to the role of a judge in interpreting the constitutionality of a piece of legislation? Are they the same or are they different?
They're quite different. A judge isn't expressing a policy view. You know, I tell my students in constitutional law that newspapers do courts a disservice when, you know, they say things like, you know, court favors same-sex marriage, or, you know, just giving the headline without showing any of the reasoning that goes into it. Because courts are not just expressing a policy preference, they're digging in, they're looking at the precedent, they're looking at the Constitution, and even when the result cuts against policy preferences, judges are obliged to follow them. I suspect that this body doesn't cast votes that conflict with their policy preferences.
Well, that's right. And the difference between us and you is you don't run for election.
That's right.
You don't run on a platform. You don't say, if I'm confirmed, I'm going to do this or that. You don't do that, do you?
It would be wholly, wildly inappropriate for me to do so.
Well, your mentor, Justice Scalia, said something back in 2005 that I find intriguing but reassuring. He said, if you're going to be a good and faithful judge, you have to resign yourself to the fact that you're not always going to like the conclusions you reach. If you like them all the time, you're probably doing something wrong. Do you agree with that? And if you do, would you explain what you mean?
I do agree with that, and that, you know, has been my experience on the Seventh Circuit so far. It's your job to pass the statutes, it's your job to choose policy, and then it's my job to interpret those laws and apply them to facts of particular cases. And they don't always lead me to results that I would reach if I were, you know, queen of the world and I could say, you win, you lose, or this is how I want it to be, because I just don't have the power by fiat to impose my policy preferences or choose the result I prefer. That's just not my role. I've got to go with what you guys have chosen.
Well, why in the world would the American people surrender their right to govern themselves through their elected representatives and through the Constitution to 9 people who don't even run for election and who serve for life? Why in the world should the American people do that?
Well, I think part of the rationale for courts adhering to the rule of law and for judges taking great care to avoid imposing their policy preferences is that it's inconsistent with democracy. Nobody wants to live in accord with the law of Amy. I'm sure my children don't even want to do that. So I can't, as a judge, get up on the bench and say, you're going to live by my policy preferences because I have life tenure and you can't kick me out if you don't like them.
Well, thankfully, under the Constitution, even if the Supreme Court strikes down a statute, Congress can come back and revisit that topic and do so in a way that doesn't violate the Constitution as determined by the court. And ultimately, it doesn't happen very often in our history, but ultimately we can amend the Constitution itself, correct?
That is correct.
So the basis of legitimacy of governmental power is consent of the governed. Do you agree with that?
I do agree with that.
Not what 9 people in black robes, the high 9 on the Potomac, I think they're sometimes called, the decisions they make. That's not the final word in our form of government, correct?
We are a government of laws, not of men.
Well, Judge Barrett, I'm almost through, but I can't pass up the opportunity to ask you a question about the Establishment Clause. I did with Justice Kavanaugh and Justice Gorsuch as well. It's born out of my frustration one of the couple of times I had a chance as Attorney General of Texas to argue before the Supreme Court. I argued in a case called Santa Fe Independent School District versus Doe. This was about a commonplace practice where before football games in Texas, students would volunteer to offer a invocation or an inspirational poem or saying or something like that. The ACLU sued the school district, and obviously it made its way all the way to the Supreme Court. And I'm not going to ask you your opinion on the outcome of the case, but what troubled me the most about that experience is when the Supreme Court struck down or held that practice unconstitutional and in violation of the Establishment Clause. Chief Justice Rehnquist said the Constitution requires neutrality toward religion, but the court's approach speaks of hostility toward religion. Could you just talk a little bit about the Establishment Clause generally, with not in regard to any particular set of facts, but sort of what the courts over time have tried to do to enforce the mandate of the Constitution?
Well, Senator Cornyn, when I interviewed for my job with Justice Scalia, he asked what area of the court's precedent that I thought, needed to be better organized or that sort of thing. And off the cuff, I said, well, gosh, the First Amendment. And he said, well, what do you mean? And I fell down a rabbit hole of trying to explain without success, because it is a very complicated area of the law, how one might see one's way through the thicket of balancing the Establishment Clause against the Free Exercise Clause. It's a notoriously difficult area of the law. And to the extent that, there is tension in the court's cases, and I'm giving you no better an answer, I assure you, than I did to Justice Scalia that day, it's been something that the court has struggled with, for decades to try to come to a sensible way to apply both of those clauses.
Well, I wish you well.
Thank you, Senator.
Mr. Chairman, I'm going to reserve the rest of my time.
Thank you, Senator Cornyn. For planning purposes, if it's okay with the committee, we'll have Senator Durbin and Senator Lee. We'll break for about a half hour for lunch and come back with Senator Whitehouse. Is that okay? Senator Durbin, are you okay with that? Do you need a break?
No, that's fine.
Okay.
Thank you, Mr. Chairman, and thank you, Judge Barrett, and your family for being here with us today for this marathon of questioning.
Thank you, Senator Durbin.
Appreciate it. I would like to respond to two of my colleagues quickly before I ask a few questions of you. Who came up with this notion, this insulting notion that you might violate your oath? Where could this idea have come from? Could it have come from the White House? Could it have come from the president's tweets of what he expects a Supreme Court nominee to do politically for him? That's where it comes from. That's where it originated. And you have said very clearly today, without equivocation, you are not going to be influenced by President Trump's importuning or the importuning of this committee or anyone else, which is what we expect you to say. But this notion that this whole idea of your being used for political purposes is a democratic creation. Read the tweets, and you have plenty to work with. Read the tweets. The second thing I would like to say is I'm not going to spend a lot of time defending the Affordable Care Act, although I think it's the most important single vote I've cast as a member of Congress, period. But I will say that when the chairman opened up on it and said what he did, I was puzzled. 3 states get 35% of the money? How can that possibly be true? Well, it turns out because those states decided to extend Medicaid coverage to the people who lived in the states, and his did not. And as a consequence, fewer people in South Carolina have the protection of health insurance, and those that do are paying for their services, and those that don't are not, which imperils hospitals and others in the process. So I would say there is an explanation as to why some states are spending more. And incidentally, there was a Republican governor of your state, Indiana, by the name of Mike Pence, who decided to break with other Republican governors and extend Medicaid coverage under the Affordable Care Act. I think it was the right thing to do for Indiana as it was for Illinois. But that's part of the reasoning. Let me just say that the Affordable Care Act really is at the heart of this, as you can tell on the Democratic side. We really believe the Supreme Court's consideration of that case could literally change America for millions of people. I have with me today another group I'd like you to at least be aware of, because they're pretty amazing people. But this is the Williams family. They live in Naperville, not too far from Chicago.
Yeah.
Kathy and Les Williams have 4 sons from left to right: Matt, Joey, Tommy, and Mikey. Matt, who's 27, was diagnosed with type 1 diabetes when he was 13. The other 3 Williams boys were all born with cystic fibrosis. Joey is 24, Mikey's 21. Sadly, Mikey's twin, Tommy, after this picture was taken, passed away in January 2019 from complications. This is the last photo that was ever taken of their full family. Here's what they wrote me. We cannot imagine having to go through losing another child. People with cystic fibrosis require daily medication, regular doctor visits, access to high-quality specialized care. That means people with pre-existing conditions like cystic fibrosis cannot be discriminated against. The ACA's protections ensure a ban on annual and lifetime caps and enforce the requirement that insurers cover essential health benefits such as hospitalizations or mental health services. People with CF and other pre-existing conditions need adequate, affordable health care to live longer, healthier lives. That's why we keep bringing this up. Real people that we run into all the time. There's a chart here I might show too, Dan, while we're at it. On the Republican side, there's some obvious controversy as to whether we're right or wrong. But there are an awful lot of people in each of the states represented by our Republican senators who have their health care and literally, in some cases, their lives hanging in the balance. South Carolina, 242,000 people would lose their insurance coverage if the Affordable Care Act were eliminated. 2 million living in that state have pre-existing conditions. You can imagine the list goes on. Thank you. Here's what it comes down to. You've been unequivocal in being critical of the decisions both in NFIB Sebelius and in King Burwell. And we naturally draw the conclusion there's going to be a third strike when it comes to Texas and California. You said it won't affect pre-existing conditions. If the petitioners have their way, there will not be an Affordable Care Act to protect pre-existing conditions on the severability question. So give us an insight how you can be so unequivocal in opposing the majority decisions in NFIB Sebelius and in King and Burwell, but have an open mind when it comes to the future of the Affordable Care Act.
Sure. Thank you for that question, Senator Durbin, because it gives me an opportunity to make my position clear. When I wrote, and this was as a law professor, about those decisions, I did critique the statutory interpretation of the majority opinions. And as I mentioned before, my description of them was consistent with the way that Chief Justice Roberts described the statutory question. But I think that your concern is that because I critiqued the statutory reasoning, that I'm hostile to the ACA, and that because I'm hostile to the ACA, that I would decide a case a particular way. And I assure you that I am not. I'm not hostile to the ACA. I'm not hostile to any statute that you pass. And the cases on which I commented, and we can talk at another time, I guess, about the context, the distinctions between academic writing and judicial decision-making, but those were on entirely different issues. So to assume that because I critiqued the interpretation of the mandate or the phrase established by a state means that on the entirely different legal question of severability, I would reach a particular result, just assumes that I'm hostile. And that's not the case. I apply the law, I follow the law, you make the policy.
So let's talk about that for a moment from a different issue perspective. Bear with me for a couple questions. Have you seen the George Floyd video?
I have.
What impact did it have on you?
Senator, as you might imagine, given that I have 2 Black children, that was very, very personal for my family. Jesse was with the boys on a camping trip out in South Dakota, so I was there, and my 17-year-old daughter, Vivian, who's adopted from Haiti, all of this was erupting. It was very difficult for her. We wept together in my room. And then it was also difficult for my daughter Juliet, who's 10. I had to try to explain some of this to them. I mean, my children to this point in their lives have had the benefit of growing up in a cocoon where they have not yet experienced hatred or violence. And for Vivian, you know, to understand that there would be a risk to her brother or the son she might have one day of that kind of brutality has been an ongoing conversation. It's a difficult one for us, like it is for Americans all over the country.
And so I'd like to ask you, as an originalist who obviously has a passion for history, I can't imagine that you could separate the two, to reflect on the history of this country. Where are we today when it comes to the issue of race? Some argue it's fine. Everything's fine, and you don't have to even teach children about the history of slavery or discrimination. Others say there's implicit bias in so many aspects of American life that we have to be very candid about and address. Others go further and say, no, it's systemic racism that's built into America, and we have to be much more pointed in our addressing it. How do you feel?
So I think it is an entirely uncontroversial and obvious statement, given, as we just talked about, the George Floyd video, that racism persists in our country. As to putting my finger on the nature of the problem, you know, whether, as you say, it's just outright or systemic racism, or how to tackle the issue of making it better, those things, you know, are policy questions. They're hotly contested policy questions that have been in the news and discussed all summer. So while, you know, as I did share my personal experience, I'm very, you know, happy to discuss the reaction our family had to the George Floyd video. Giving broader statements or making, you know, broader diagnoses about the problem of racism is kind of beyond what I'm capable of doing as a judge.
Well, I would doubt that. I just don't believe you can be as passionate about originalism and the history behind language that we've had for decades, if not centuries, without having some thought about where we stand today. But I'm not going to press you on that. I'm going to take you to a case which I have read and reread, Cantor versus Barr. Mm-hmm. And you know the case well because it's already been referred to. Mm-hmm. And it clearly is a case where you had your day in court. You wrote the sole dissent. In a 64-page case, 37 pages were your dissent. So you gave to the court, I assume, a pretty full accounting of your thoughts on the subject. And here's the way I understand the case. A fellow named Ricky Cantor from Mequon, Wisconsin, invented some pads to put in a shoe
I'm a
to be
Verizon
sold
engineer,
to particularly
and
older
today,
Americans
we're
under
turning on-
Medicare to relieve foot pain. And he designed them and submitted them to Medicare and didn't get the approval that he was looking for, but instead sold them and represented to many customers that they had been approved by Medicare. Mm-hmm. And so he was charged with fraud. Now, this wasn't a matter of a casual misapplication of the law. When it was all said and done, Ricky Cantor of Mequon, Wisconsin, ended up spending over a year and a day in federal prison, paying somewhere near $300,000 in penalties and fines, and $27 million in a civil settlement on this issue. So this was not a casual wrongdoing. This man was a swindler, and he was taking the federal government for a ride, as well as other customers, and misleading senior citizens about his product, and paid a heavy price for it. Then he decided, having left prison, that it's just fundamentally unfair, that the law says that if you've been convicted of a felony, you can't own a firearm. Now, I don't know what his appetite is when it comes to firearms, whether it's a revolver or a AK-47 with a banana clip. I have no idea. But he went to court and said, this is unfair. It was just mail fraud, and you're taking away my Second Amendment rights. So 2 out of 3 of your colleagues then basically said, sorry, Ricky, you have forfeited your right to own a firearm because of your conviction of a felony. You took a different approach, exactly the opposite approach, and went deep into history. I think the earliest citation I see here was 1662, to figure out just what was going on here and whether or not he had to have committed a violent felony to have forfeited this right to own a firearm. Have I stated the facts close to what you remember?
I don't remember the amount of the loss, some of those details, but yes, Ricky Cantor was convicted of selling fraudulent shoe inserts, and it was a felony.
$27 million settlement along the way. So I'd like to take you into your thinking on this. When the Heller decision was handed down, Justice Scalia expressly said, I'm not taking away the authority of government to impose limitations based on felonies, not violent felonies, felonies and mental illness. He said as much in the Heller decision. And yet, this man who was your inspiration, as you've told us all, you decided he was wrong and that it had to be a violent felony. Can you explain why?
I can. So we've talked about precedent, and in my court, the Seventh Circuit, there is precedent saying that that phrase doesn't control, as my colleague Judge Frank Easterbrook has said a number of times, that judicial opinions aren't statutes and shouldn't be read as if they were. So Heller obviously wasn't about the scope of the right, its application to felons or those who are mentally ill, et cetera. And so that passage was dicta. It didn't fully dive down into it. But what I did was apply Heller's methodology, both Justice Scalia's majority opinion and Justice Stevens' dissent used an originalist methodology to answer that question. And I concluded that based on that history, one couldn't take the right away simply because one was a felon, that there had to be a showing of dangerousness. And I didn't rule out the possibility that the government might be able to make that showing about Ricky Cantor. But I think we could all agree that we ought to be careful of saying that because someone's a felon, they lose any of their individual rights.
I want to get to that point, but I'd like to stick with this for just a moment more. I'm honored to represent the city of Chicago and the state of Illinois. It's a great city, but it has great problems too, and one of them is gun violence. On the average, we know in America, 100 Americans are killed every day by gunfire, 40,000 per year. In the city of Chicago, more than 3,200 people have been shot just this year, 3,200. According to the city's gun trace report in 2017, the majority of illegally used or possessed firearms recovered in Chicago are traced back to states with less regulation over firearms, such as Indiana and Mississippi. The 2017 report found that Indiana alone was the source of 21% of all Chicago's recovered crime guns. We know how it works. Where you live, you know how it works. There's a traffic between Chicago, northern Indiana, and Michigan going on constantly. Gun shows are held in Gary, Indiana, and other places. And when they're selling these firearms without background checks, unfortunately, these gangbangers and thugs fill up the trunks of their cars with firearms and head into the city of Chicago and kill everyone from infants to older people. It's a horrific situation. Law enforcement is fighting it, trying to get Indiana to at least do background checks at these gun shows with limited success. And we are trying to apply the standards that you disqualify yourself from buying a firearm to felonies and mental illness. And you want to take away part of that protection with your decision in this case. Because if you eliminate felonies and just confine it to violent felonies, you're opening up more opportunities for people to buy firearms, are you not?
Well, Senator, you referred to gang members and thugs buying guns in Indiana and taking them across the border. And certainly that, if they had felony convictions for doing the kinds of things that members of gangs and thugs do, nothing in Cantor says that the government can't deprive them of firearms. And nothing says, in my opinion, that the government can't deprive Ricky Cantor of having firearms. They simply had to make a showing of dangerousness before they did so. And nothing in the opinion opines at all on the legality of background checks, and gun licensing. Those are all separate issues.
But the majority zeroes in and says what you've just said is totally impractical, that we are going to go case by case and decide, well, what kind of felonies and what kind of person. And then they go on to produce evidence. I could read the numbers here, but you know them well because you wrote the dissent, where the likelihood of committing a violent felony after being convicted of a felony is pretty dramatic. And they're saying to us, don't force us to make it case by case. We want to make it by category. It's the only practical way to deal with the thousands, if not millions, of people who are buying firearms. You are aware of the fact that even those who are so-called not violent felons, quote, only felons, like Ricky Cantor, have a propensity to commit violent felonies in the future, are you not?
There was no evidence of that in the case. And we, on courts, for example, the Armed Career Criminal Act, that's a federal statute, have to make judgments categorically all the time about what count as crimes of violence. So I don't think that's beyond the ken of courts in any area to identify which felonies are violent and, which felonies are not.
So let's excuse me, but I won't address that issue. Let's go to page 21 of the opinion and what the court said, the majority in the court. They quoted Yancey. Most felons are nonviolent, but someone with felony conviction on his record is more likely than a non-felon to engage in illegal and violent gun use. For example, one study, this goes on to say, 210,886 nonviolent offenders found that 1 out of 5 were rearrested for a violent crime within 3 years. So the evidence is there. It is there for the court to consider, and you ignored it.
Senator, I didn't ignore it. As I recall, that evidence and the studies were unclear. And let's see. I can't remember as I'm sitting here the details of all the statistics, but I did consider it, and I recall saying something in the opinion about the reliability of those studies, because they didn't say whether someone had been convicted of a nonviolent crime but had later been convicted of a violent crime as well. I mean, felonies cover a broad range of things, including selling pigs without a license in some states, redeeming too many bottle caps in Michigan. I mean, so felonies now cover a broad swath of conduct, not all of which seems indicative of whether someone's likely to abuse a firearm.
So let me take you, I'm not going to go so far back in history, but I'm going to take you back in history for a moment and note that when that Second Amendment was written and you did the analysis of it, we were talking about the likelihood that a person could purchase a muzzle-loading musket. We are now talking about virtual military weapons that can kill hundreds of innocent people. It is a much different circumstance. Maybe an originalist pins all their thinking to that musket, but I've got to bring it to the 21st century. And the 21st century has people being killed on the streets of Chicago because of the proliferation of deadly firearms. But let me bring it closer to home and tie up the George Floyd question with where I'm headed. There's also a question as whether the commission of a felony disqualifies you from voting in America. And the history on that is pretty clear. In an article, the American Journal of Sociology found that many felony voting bans were passed in the late 1860s and 1870s when implementation of the 15th Amendment and its extension of voting rights to African Americans were ardently contested. It still goes on today with voter suppression. But we know that in Reconstruction, in the Jim Crow era, in Black Code era, that was used. A felony conviction was used to disqualify African Americans from voting in the South and many other places. The Sentencing Project today has found that more than 6 million Americans can't vote because of a felony conviction, and 1 out of every 13 Black Americans have lost their voting rights. The reason I raise that is that in your dissent, you said disqualifying a person from voting because of a because of a felony is okay. But when it comes to the possession of firearms, wait a minute, we're talking about the individual right of a Second Amendment. What we're talking about in voting is a civic right, a community right, however you define it. I don't get it. So you're saying that a felony should not disqualify Ricky from buying an AK-47, but using a felony conviction someone's passed to deny them the right to vote is all right?
Senator, what I said was that the Constitution contemplates that states have the freedom to deprive felons of the right to vote. It's expressed in the constitutional text, but I expressed no view on whether that was a good idea, whether states should do that. And I didn't explore in that opinion, because it was completely irrelevant to it, what limits, if any, there might be on a state's ability to curtail felon voting rights.
Did you not distinguish the Second Amendment right from the right to vote, calling one an individual right under the Constitution and the other a civic right?
That's consistent with the language in the historical context, the way the briefs described it, and it was part of the dispute in Heller of whether the Second Amendment was an individual right or a civic one that was possessed collectively for the sake of the common good. And everybody was treating voting as one of the civic rights.
Well, I will just tell you that the conclusion of this is hard to swallow. The notion that Mr. Cantor, after all that he did, should not be even slowed down when he's on his way to buy a firearm. My goodness, it's just a felony. It's not a violent felony that he committed. And then to turn around on the other hand and say, well, but when it comes to taking away a person's right to vote, that's the civic duty. It's something that we could countenance. That really goes back to the original George Floyd question. That was thinking in the 19th century that resulted in voter suppression and taking away the right to vote from millions of African Americans across this country. And it still continues to this day. I just don't see it. I think the right to vote should be given at least as much respect as any Second Amendment right. Do you?
Senator, the Supreme Court has repeatedly said that voting is a fundamental right, and I fear that you might be taking my statement in Cantor out of context. What I said in that opinion was distinguishing between, it was a descriptive statement of the state of the court's case law, comparing it to stripping felons of Second Amendment rights. I expressed no view about what the constitutional limits of that might be, or whether the law should change with respect to felon voting rights. And obviously that's a contested issue in some states that are considering it right now. And I have no view on that, and it wasn't the subject of Cantor.
It may not have been, it wasn't the subject of the case, that's for sure. But in your writings, you raised this. It was part of your dissent, discussing the right to vote and felony conviction, eliminating it. I'm afraid it's inescapable. You've got to be prepared to answer this kind of question. I read it and thought, I can't imagine that she's saying this, but I'm afraid I was left with the suggestion you might. Which brings me to the conclusion here. We hear over and over from the other side of the aisle, we don't want any activist judges. We want judges who are going to go back to the original document, literally take it word for word, put it in a historical context, and don't get in the way of making laws. We make the laws, you're a judge, you stay away from them. And yet, when we look at this case, the notion of what disqualifies you from buying a firearm was being rewritten by the dissenting judge and saying, when we say felony, we just mean violent felony. Well, the word violent isn't in there, but you found it, or at least found reference to it. It's not the only time this has happened. In Citizens United and its progeny, Republican-appointed justices struck down bipartisan campaign finance reform to unleash a flood of dark money into our political system. Part of that flood is paying for the ad campaign promoting your nomination for the Supreme Court. I know you've said you've gone radio silent in following the media. I don't blame you. I do the same thing politically. But I can just tell you, I've seen them. They are beautiful, expensive ads boosting your nomination for the Supreme Court from organizations we've never heard of, spending millions of dollars to make sure you get on the Supreme Court. Citizens United opened the door for that. And in Shelby County, conservative justices gutted the Voting Rights Act to unleash a wave of voter suppression across the country, going back to the George Floyd moment. Unfortunately, a lot of it is for racial purposes. And this is an example, 2 or 3 examples that I've given here, of activist judges rewriting the law, abolishing the law. People have to get real. As I said to you on our phone conversation, I don't think you put the facts here and the law here and 9 justices come to the same conclusion. Cases are 5-4, 6-3, 7-2 unanimous. People see things differently based on their backgrounds, their values, their experience. And I think it's simplistic to think this is a robotic performance. Once we put a judge on the bench, they just go back, read the Constitution, and rule. It's not that simple. And I think you've acknowledged that by saying even originalists disagree with one another. Is that true?
Yes, law is hard and it's complicated, and people who approach it from different jurisprudential perspectives will sometimes reach different results. I mean, I think that's hard to deny because, as you say, every vote from the Supreme Court isn't unanimous, and sometimes it is, but cases don't get to the Supreme Court unless the circuits disagree among themselves. So it's hard. But to the extent, Senator Durbin, that you're suggesting that I have some sort of agenda on felon voting rights or guns or campaign finance or anything else, I can assure you and the whole committee that I do not.
I didn't say that, and I wouldn't say that. But I will say that you come, if you're successful in this pursuit, you come to the Supreme Court with life experiences. You come to the Supreme Court having read a lot, I'm sure, and drawn some conclusions in your own mind about certain things and certain issues. Everyone on the court has that same background. They bring something to it that is just not generic, it's individual. And that's the point I'm making. There's an individualism to this. The class of originalists on the Supreme Court are not all going to vote the same on every case. And I think merely saying originalism does not absolve you or us from observing the obvious. There are going to be differences. I think, would you like to say something? I don't want to cut you off.
No, that's okay.
Okay, thank you very much.
Thank you, Senator.
Senator Durbin, we'll go to Senator Lee, and after that, we'll take a 30-minute lunch break and start back with Senator Whitehouse. Senator Lee.
Thank you, Mr. Chairman. I have two letters for the record that I'd like to have admitted. They're authored by former law clerks of Judge Barrett's.
Without objection.
I'd encourage all of my colleagues to read them. They're outstanding and provide great insight into Judge Barrett's immense qualifications. Judge Barrett, moments ago, we went through a rather interesting set of exchanges. One of my colleagues, I hope I misunderstood him, seems to have suggested that it's a political talking point for you to decline to indicate how you would rule on a particular case or a particular type of case. To the extent that that's what any colleague has suggested, I'd remind that colleague that's just wildly incorrect. It's wildly incorrect with canons of judicial ethics, with federal law, with the statement laid out by Justice Ruth Bader Ginsburg in her own confirmation proceedings before this very body in this very room nearly 30 years ago. It is imperative that you uphold those standards, and I applaud you for doing so. And I think on no planet is it appropriate for anybody to suggest that that's a political talking point for you to say, I'm not going to indicate how I'm going to rule in a particular case. Justice Ginsburg did, in fact, say it well, and some of this has been quoted today. I'm going to quote it again just for good measure. She said, judges in our system are bound to decide concrete cases, not abstract issues. A judge sworn to decide impartially can offer no forecast, no hints, for that would show not only disregard for the specifics of a particular case, it would display disdain for the entire judicial process. Similarly, because you are considering my capacity for independent judging, my personal views on how I would vote on a publicly debated issue were I in your shoes, were I a legislator, are not what you will be closely examining. That's what she said. She said it well. It was true in 1993, and it remains true today. I want to turn next to a line of questioning that you just finished, that you just completed. I, too, have read the Cantor case, and I am thrilled that we've got a jurist who is willing, when looking at somebody whose constitutional rights are about to be taken away, thrilled to have a jurist who's willing to consider a pre-deprivation review for that individual. Is it unusual, Judge Barrett, to consider someone's constitutional rights on an individualized basis before having a specifically enumerated, constitutionally protected right removed?
That would be very, very unusual.
It would be very, very unusual, and it would be unwise, would it not?
Well, I think what I could say to that, just to be careful about how much law I'm analyzing, is that the 14th Amendment Due Process Clause certainly guarantees to each individual due process before liberty is taken away.
I also appreciated the thorough analysis that you undertook, making clear that our rights in this area don't just date back a few decades. They don't just date back to the 60s. They don't date just back to the 1780s or the 1760s. They date back at least to the 1660s. I mean, they go way, way back. There's a lot of history that went into what became the Second Amendment. There were conflicts. This involved not just partisan conflicts, but conflicts between the king and subjects. And not just between the king and subjects in the abstract, but very often it was between Protestants and Catholics. Sometimes it was Catholics who weren't trusted with guns. Sometimes it was Protestants who weren't trusted with guns. But there was a lot of violence that went into that and that led to our adoption of that amendment. I appreciated your historical analysis of this, your willingness to be thorough, to make sure that when someone's constitutionally protected rights are taken into account, you're going to do your homework. You're going to do your homework even if it's hard. You're going to do it even if you've got colleagues who aren't willing to go there. That's what judicial leadership is. Judicial leadership involves willingness to stand alone. Judge Barrett, one of the things that came out to me as I read your opinion in the Cantor case is that your commitment to textualism and originalism are in fact real. They're not feigned. This is the kind of thing you can't fake. This isn't something you make up at the last minute. And yes, I agree with Senator Durbin. Being a textualist and originalist doesn't guarantee a particular result, a particular outcome in any particular case. But it does indicate a style, a preference. Tell me why textualism and originalism are important to you.
Because I think that both statutes and the Constitution are law. They derive their democratic legitimacy from the fact that they have been enacted in the case of statutes by the people's representatives, or in the case of the Constitution, through the Constitution-making process. And I, as a judge, have an obligation to respect and enforce only that law that the people themselves have embraced. As I was saying earlier, it's not the law of Amy, it's the law of the American people. And I think originalism and textualism, to me, boil down to that, to a commitment to the rule of law, to not disturbing or changing or updating or, adjusting in line with my own policy preferences what that law requires.
And is it the subjective motivation, the subjective intent of an individual lawmaker or drafter of a constitutional provision that we're looking at, or is it original public meaning? And if so, what's the difference between those two?
It's original public meaning, not the subjective intent of any particular drafter. So one thing I have told my students in constitutional law is that the question is not what would James Madison do. We're not controlled by how James Madison perceived any particular problem. That's because the law is what the people understand it to be, not what goes on in any individual legislator's mind. I respect you greatly, Senator Lee, but what you think in your mind rather than what passes through both houses and is signed by the president, that's what's the law, not any private intentions you have.
So regardless of what, let's say I pass Bill XYZ, and I'm the sponsor of it. I take it down to the floor, and I say, here's Bill XYZ, and here's what I think about it. Here's what I intend to do with it. And I put that statement into the legislative record. What, if any, impact should that statement have on the meaning of law XYZ once it becomes law?
Nothing. You got to get it into the law itself if you want it to be law. Legislative history is not what goes through the process of bicameralism and presentment.
Regardless of how passionately and persuasively I make that point in whatever glorious speech I give in support of Bill XYZ, it doesn't make a darn bit of difference, does it?
It doesn't. I'm sure the speech would be glorious, but I assume the point you make probably would be made by the advocates in the case too. And so in that respect, you are functioning as an advocate when you make the glorious statement, but not speaking with the voice of the lawmaker, because no individual does. It's the full body that speaks.
I want to speak next about the Affordable Care Act. We've seen posters going up over and over and over again. We've seen them yesterday. We've seen them today. We've seen a lot of compelling stories about people whose lives have been marked by difficult things that they've endured. They've involved touching and heartwarming stories. I continue to doubt the relevance of things like that here, especially insofar as they're being used to suggest that your confirmation to the Supreme Court of the United States has anything to do with their health care. Tell me why you think that any individual American's health care status is or is not tied to your confirmation to the Supreme Court of the United States.
It is not tied to my nomination to the Supreme Court of the United States. I have said repeatedly under oath that I had no conversations with anyone in the White House about that case. And I'm not sure, to the extent there's a suggestion that I have an agenda that I want to strike down people's protection for pre-existing conditions. That's just not true. I've never taken that position. And as I've also said repeatedly, any policy preferences that I have don't matter anyway. They're irrelevant. So making that law, coming out with the contours of the ACA, that's your job.
It is our job. It is the job of policy-making branches of government. It's the job of whatever combination of state and federal lawmakers and other policymakers have. But a judge is not a policymaker. When Congress passes a law, Congress is in charge of making sure that that law works. Insofar as that doesn't work or that law ends up being stricken down, it's our job to replace it with something that does work, whether constitutionally or otherwise in all respects. That's our job, not yours. You made some comments a few years ago, comments with which I wholeheartedly agree. Raising a criticism with Chief Justice Roberts and his majority decision in NFIB versus Sebelius. A decision, and don't worry, I'm not going to ask you to weigh in on this. You made those comments at the time, and they're not relevant to me now, but I set this up for reasons I'll explain in a moment. He rewrote the Affordable Care Act, not just once, but twice, in substantive ways, in order to save that law from an otherwise inevitable finding of unconstitutionality, because that law, as written by this Congress, was in fact unconstitutional in two material respects at issue in NFIB versus Sebelius. Blatantly unconstitutional. He effectively acknowledged that the law, as written, couldn't pass constitutional muster. And so he rewrote it, not just once, but twice, in order to save it. That's water under the bridge. That happened. It's inexcusable that he did that. He misused the judicial authority. That case has absolutely nothing to do with California versus Texas. It has absolutely nothing to do with the question of severability in that case. Would it be fair to say that my very strong opinions that I've just expressed do not indicate how I would feel, how I would lean were I a jurist in California versus Texas?
I think you're correct, Senator Lee, that the legal issue is entirely different in California versus Texas. Severability is its own independent doctrine and has nothing to do with the statutory interpretation questions presented in Sebelius.
In many circumstances in this country, we see emotionally charged issues that boil for a long time. They can't always be resolved. Not everybody's going to agree on everything. Not everybody is going to agree on certain hot-button social issues that result in some cases from just basic differences in how people view life and how people view their place in the universe. One of those areas where it manifests itself is in the area of abortion. People view life and when it begins differently. Some of that's informed by religious beliefs. Some of it's informed just by people's common sense approach to what they think the law ought to say and what it ought not to say. Disputes regarding when life begins and disputes regarding abortion didn't begin with Roe versus Wade. What did change with Roe versus Wade, however, was the federalization and the grasping of the issue and the taking it beyond the realm of political debate within the federal judiciary, such that elected lawmakers we're no longer in a position to be the primary drivers of policy. As a result, over the last few decades, you've had all kinds of questions that have been put into uncertainty. You've got uncertainty by people at the state level who want to make their own decisions about certain things around abortion. They know they can't prohibit it entirely. They know that there's this undue burden standard that has to be addressed. Nobody's completely sure in advance what that means, and so they work around it. There are discussions that arise regarding health and safety qualifications for abortion clinics, how close an abortion clinic needs to be to an accredited hospital, how it needs to be staffed, and what the sanitation protocols are. Then you've got, more recently, some states passing laws saying, look, there's abundant medical science showing that an unborn human can feel and respond to pain as early as, 10 or 12 gestational weeks, but certainly by 20 weeks. And so by 20 weeks, we're going to adopt a different set of legal procedures for an abortion as a result of that, because if this is a human that everybody agrees can feel and respond to pain, we ought to handle that differently. All of those things, the legitimacy of those laws, are thrown into the federal courts yet again, all because those were made federal issues. Now, I want to be very clear. You'd have the impression from watching debates in circumstances like this one and in protests outside the Supreme Court of the United States, you'd have the impression that if Roe versus Wade didn't exist, that all of a sudden abortion would immediately become illegal in every state in America. That assumes a lot of facts not in evidence. In fact, that assumes a lot of things contrary to evidence. It is not the fact that it is simply not the case that the fate of healthcare in America turns on whether or not someone is confirmed to the Supreme Court of the United States, nor is it a fact to suggest that the availability of an abortion or lack thereof is contingent upon anyone's confirmation to the Supreme Court of the United States. The fact that we have this debate and the fact that it's become as protracted, as personal, as ugly as it has, could, I suspect, be traced to the fact that we've tried to take a debatable matter beyond debate. And we've tried to take it outside the political branches of government where people can elect their individual representatives and have laws respecting and reflecting the views of their respective communities. We're a country of, 330 million Americans. It's really, really difficult to have those 330 million Americans reflected in 9 members of the Supreme Court. It's still really hard to have them reflected in 100 senators and 435 representatives. That's doable, especially when those people are elected. They stand for election every couple years in the case of the House, every 6 years in the case of the Senate. It doesn't happen that way in the Supreme Court of the United States. So to my colleagues on the other side of the aisle, who are fear-mongering on this, causing people to worry and lose sleep over this, fundraising over this, fundraising over threats that people are going to lose their health care, fundraising over threats that people are going to be dying in the streets because of the lack of availability of this or that medical procedure. I'd ask, have we created a monster? Have we ourselves, through our own inaction, through our own voluntary cessation of authority to a non-legislative, non-political branch, have we created the very set of untenable social circumstances that are causing people to protest outside of a non-political entity? I think we have to ask ourselves that question from time to time. Life is, in fact, valuable. It's not a religious statement to make that observation. In fact, it's the foundation of basically all of our laws, not just in this country, not just in countries with Christian origins, but in basically every country that has ever existed anywhere in the world. The purpose of government is to protect life. That's what it's about. If we can't agree on the fact that it's reasonable that people ought to be able to have some say, at least at some limit, at least at some point beyond the moment when an unborn human can feel and respond to pain, something's wrong with us. And if we're going to leave those things perpetually in the hands of the unelected, it might be really convenient for political fundraising within Congress, but it's not good for the United States of America. It's not good for constitutionally limited government. It's not good for our individual liberties. Judge Barrett, Alexander Hamilton was prescient in a number of areas. He had some crazy ideas. He did some crazy things. He was also freaking brilliant. I think he foresaw certain aspects of our lives when he described the differences between the branches of government in Federalist 78. And in Federalist 78, he said that the legislative branch, Congress, being a political branch, a branch whose job it is to make policy, to make law, was possessed with will, and that what's possessed by the judicial branch is not will, but judgment. He then went on to explain that it's really important to maintain that clear distinction between will and judgment, lest you have the judicial branch consisting of people who are not elected by the people, not accountable to the people at the regular intervals, and who serve basically for the rest of their lives so long as they're on good behavior. You can't have them exercising will because it's not their job. What do you think he meant? What's the difference between will and judgment?
I think will is the imposition of policy preferences as happens in the making of law. Judgment is evaluating that law for its consistency with the Constitution, for example, or, to give another example, to interpret what that law means. But it most certainly is not the imposition of policy preferences. A judge who approaches a case as an opportunity for an exercise of will has has betrayed her judicial duty.
How does she know when she's reached that point?
So I think it requires disciplined judicial decision-making. So you approach the text, you treat it as a text, you treat it as law. You know, I've described originalism and textualism, so I won't belabor that point. But I will say that one practice that I have, one check that I put on myself to make sure that I'm not biased, is that when I write an opinion, I try to read it from the perspective of the losing party, so that any sympathy that I might feel for the particular result that I reach, I try to make the sympathy run the other way to see if it will still hold, and also to see, like, you know, I would be disappointed in this outcome if it was my child whose sentence or criminal conviction or civil loss, whatever it is on the line, but would I still think it was a well-reasoned opinion? And that's the test that I use for myself. I think discipline is required, but I take it very, very seriously.
As we've had this conversation today, one of the arguments that's been made by some of my colleagues is referred to activism, and has accused, if I understood the argument correctly, some textualist, originalist jurists as having engaged in activism. Now, I want to be clear. I'm one who doesn't believe that there is anything worse about an activist judge than a pacifist judge. Meaning, I think it's every bit as bad to be a pacifist. That is, for example, to let stand an invalid unconstitutional law as if it were valid and constitutional. It's every bit as bad to do that as it is to invalidate as unconstitutional something that is, in fact, not unconstitutional. Would you agree with me that both of those are equally instances of bad judging?
They are both instances of, as you've posed them, of not following the law, of not following the Constitution or not correctly interpreting a statute.
By the same token, a judge who fails to grant a meritorious dispositive motion and a judge who grants a non-meritorious dispositive motion. They've both probably done an equally bad thing. Is that right?
Yeah.
Does the Constitution say anything about the size of the Supreme Court?
The Constitution does not. That is a question left open to Congress. It's my understanding that it's been 9 for about 150 years, but that's as a matter of statute, not constitutional requirement.
So it's statutory. It's a statutory decision, one that stood for more than a century and a half. It's a decision, nonetheless, that has some bearing, could have some bearing on constitutional issues, correct?
Insofar as there would be more decision makers on the court?
If we abandoned the longstanding historical practice and tradition of having 9 justices, could that have an impact on the way the 3 branches of government interact with each other?
Possibly, but it's difficult for me to imagine what specific constitutional question you're asking. And of course, if there were one, I couldn't opine on it.
Of course. There are strong reasons, I believe, why over the last more than a century and a half, we've left that number at 9. As you point out, there's nothing in the Constitution that requires it. We could come up with any number we wanted. There does have to be a Supreme Court and such inferior courts as we choose to create. But it doesn't specify the number of seats that can be on there. There are nonetheless good prudential reasons having to do with respect for the separation of powers between the 3 branches of government. Reasons that have, over the last 150 plus years, left us to leave that number at 9. The last time, as far as I can tell, there was any serious effort to move the number above 9 was in the fall of 1936, when President Franklin D. Roosevelt got tired of this so-called 4 horsemen of the apocalypse, a few members of the Supreme Court who were consistently voting against his agenda, and sometimes joined by 1 or more other members of the Supreme Court. He got particularly tired of this, and so he proposed packing the court. And let me explain what I mean by packing the court here. What I mean when I refer to this is increasing the number of seats on the Supreme Court, and doing so by statute with the intent of altering the composition of the court for short-term political gain. That's what FDR wanted to do. Notwithstanding the fact that he had an overwhelming supermajority in both houses of Congress, fortunately, FDR's idea that he pushed in the fall of 1936 didn't make it anywhere. It didn't gain progress. It met enough opposition, even with both houses of Congress being overwhelmingly controlled by his political party, that it stalled quite mercifully. And it's remained ever since then at 9 justices. I think it would have been a colossal mistake. Joe Biden himself, as a U.S. Senator, as a member of this body, in a proceeding of this committee in 1983, gave a rousing speech that I recommend to all, talking about that very thing, acknowledging that the Constitution doesn't require it, but our respect for the separation of powers really ought to lead to us sticking to the number 9. Don't pack the court. In recent days, I've seen some in the media and some in this body try to redefine what it means to pack the court. Some have suggested, well, court packing takes various forms, and it can mean confirming a lot of people all at once. Some have defined it so as to suggest that it consists of doing that which the Trump administration and the Republican Senate have been doing over the last 3.5 years, which is filling vacancies as they have arisen, and doing so with textualist, originalist judges. This may not be something that some like, but this is not court packing. Court packing is itself manipulative. It's something that has great danger to do immense political and constitutional harm to our system of government, in part because it would set up a one-way ratchet. Once you create a position and confirm someone to that position, absent death, retirement, or impeachment and removal, that position remains in place. So, if, for example, a future Congress and White House were to decide to get together and to pack the court and increase the number, say, to 11, and let's say it's Democrats who do that, and we've got Joe Biden now as a presidential candidate who's refusing to say whether he would do it. There's a reason he's not saying whether he would do it. There's only one reason why you refuse to answer that question, and it's if you're wanting to be able to do it, but you don't want to take the heat for the fact that you're thinking about doing it right now. So if they do that, where does it lead? Well, it inevitably leads to the point where the next time Republicans have control of both houses of Congress and the White House, they'd increase it as well. You'd end up increasing it incrementally. Before long, it looks like the Senate in Star Wars, where you've got hundreds of people on there. I don't know what the total number would be, but you increase it at all, you change the number at all, you do so for partisan political purposes at all, you delegitimize the court. And you can't delegitimize the court without fundamentally threatening and eroding and impairing some of our most valued liberties. You can't do that without inevitably threatening things like religious freedom, things like free speech, things that are themselves often unpopular, but are protected by the Constitution precisely because they are unpopular. And yes, in that respect, the Constitution is sometimes counter-democratic. Sometimes it can be described as fundamentally undemocratic. In fact, it's the whole reason to have a Constitution, is to protect us from the impulse of a majority that might be bent on harming the few in the name of the many. That's why the law is so important. That's why the position for which you're being considered is so essential. That's why we've got to do our job to make sure that the only people who get the job for which you've been nominated fit the bill. You, Judge Barrett, are someone in whom I have immense confidence, immense trust, and I look forward to voting to confirming you for that very position.
Thanks, Senator Lee. Let's come back at 12:45. We'll start with Senator Whitehouse. We have 15 senators left. If everybody takes the 30 minutes, 7.5 hours. We'll take a break for dinner tonight, sometime later on, and a short break. Are you doing okay? 3 hours about right? So we'll come back at 12:45, and right now we're on schedule to be here to 9 o'clock, but we'll do whatever the committee wants. We're in recess to 12:45.
All right, guys. Yeah, I mean, that was incredibly boring. I'm not really sure what the point of all of this is, to be honest. It's just basically an opportunity for the Democrats to... Oh, I guess it wasn't quite over for you guys. Yeah, I mean, it's just a chance for the Democrats... 30 minutes to get you... Yeah, just for them to basically grandstand and campaign for Biden, attack Trump and the Republicans. Because they can't, there's no way they can stop this. There's nothing they can do. So they're just going to say a bunch of stuff that they think their constituents want to hear. But I got to say, they're not really fighting that hard. I mean, I expected more. Maybe we'll get more of a fight here with some of these later people, like Booker and stuff, but I doubt it because they don't really have anything to gain by it. It is funny how different already this is from the Kavanaugh hearings. I think that shows that they know they screwed up with the Kavanaugh hearings, accusing a man of gang rape and everything else that they did. It was completely insane with no evidence, just trying to destroy a man. No, I think it's all week. Maybe 4 days till Thursday. Yeah. It is still important for people, and I was getting to that, Harmony. But regardless of it being really boring and kind of painful to watch, I think it is important that we watch it because, one, the media is going to spin all this the way that they want to, and it's obviously going to be favorable to to Democrats and the Democrats in the hearing. So we have to be able to hear it and watch it and know the context, know everything that was actually said, so that we know the truth, and then, you know, we can go off, tell our friends, post about it, tweet about it, make videos, whatever. So I think that's really important to do, and that's why we're going to stream this. I am going to probably stop this stream just briefly and switch over, because I have another computer over here that I want to do it on, and I finally got it working. I finally got Streamlabs working over there while this was streaming, so I am going to stop this, but I'm going to start it right back up again. When the hearings restart, I'm just going to wait till they restart, because there's no point. I'm going to stay here with you guys for a little while here and talk. So it won't be that long. It'll be like 10 minutes or something. But make sure to stick around, and the stream will be back up. Let's see here. If you guys want to come to Discord and hang out and talk, you're welcome to. It looks like I have Ken in there to say something. Ken, if you're listening, let me know if you want to talk. Type something in Discord, let me know. Milo is in Discord. What's up, buddy? Come into the channel, the actual voice channel. I'll link that in Discord. If anybody wants to come, here's the link. Yeah, Jason Pop says, ridiculous, man. What kind of a judge is going to say one way or the other on a case they have never reviewed? And this is true. And this is something, when I'm talking about the media, this is one of the things I'm talking about. If you get on Twitter right now, you're going to, especially the CNN people around there, just like every time she doesn't answer, they're tweeting like it's some big deal. Like, oh, this is nefarious, guys. She won't answer. And then every one of these posts, I have to remind people, not that they're going to see my post, but remind anybody who might be reading that this is exactly how all the Supreme Court nominees respond to these questions. Every time. I've watched so many of these things, guys. Anyone here who's watched them, you know, this is how they always go. So, looks like we got Ken wants to put a word in, so we'll bring him in right now. Ken, you can talk whenever. Just got to unmute your mic, buddy. I'm not muted. We got somebody new. The Real Rika. Okay, the Real Rika just joined Discord. He probably wants to say something. Ken, you're welcome to start talking whenever you want, buddy. Your mic is muted, but Midnight Joker, it's a brutal fishing expedition. Yeah, I wouldn't even call it that. Because what are they going to get? They're going to get nothing. There's nothing to get there. Might as well be, you know, fishing in a pond with no fish. Daily Truth Show says, but if we are watching this, we probably already know the truth. People who watch stuff like this are usually informed. It's the low IQ left that needs to watch. True, but the more of us are watching and the more of us are informed and are out there spreading the truth, the better. You know? Oh, Ken, hold on a second. Hold on a second, guys. This always screws me up. Because it's like my settings are different for everything, so now I got to put it into headphones. Oh, my daughter's home. I can hear her upstairs getting upset.
Yeah, I said just...
All right, go ahead.
That I don't have much to say other than repeating everything that Mr. Lee just said, that all this is irrelevant, and it's just stupid what's going on right now.
Yeah. Yeah, it's really... well, I mean, it's not stupid. I mean, it is kind of stupid. It is kind of stupid because we haven't always had hearings, for one. That's a relatively new thing. And these hearings have just become big circuses. I mean, and we've had to go through way more of them, it seems like, for the Republicans because Trump's got so many picks. But
yeah,
this is I mean, they're always like this. This is why it's kind of pointless, because it's just it's a kabuki theater.
I guess the Republicans are using their time to fight back on what the Democrats say, but they're doing it in a more orderly and more respectable fashion than the Democrats are doing it. And the Democrats are only doing appealing to emotion and appealing to these ridiculous, fascinating numbers, and that has no relevance to anything, and bringing up cases that has no relevance whatsoever to this hearing, what's in any sort of meaning of the word of the of the word relevance.
Right. Yep. I mean, it is, like I said, like we just said, it's pretty much a dog and pony show. There's not a whole lot to really say about it, I don't think. Just because it's so predictable the way this is going to go, and it's kind of boring.
Well, let me speculate a bit that the Democrats are maybe using this hearing to influence the election and not the hearing, which is what the purpose of the hearing is actually for. So
Right. Well, it's going to be used just to keep advancing talking points, and the other thing that we have to mention is all the appeals to emotion. Like the entire Democrat strategy is just to throw out emotional appeals and screw fat. And I love how they keep talking about Obamacare like it's some sacred law that cannot. They talk about it like it's Roe v. Wade, right? They talk about it like it's this. Like I was just watching Crowder's his latest video, Change My Mind, and he's talking about ACB. And one of the guys he talks to is like, oh, well, we need to pack the courts because it's too political. And it's like, well, like, what are you talking about? You're fine with the politics of it. It's just you want leftist politics dominating it.
yeah, like Mr. Lee just said, then if we were to change the numbers of the people on the court, then it would just become a endless mess of hundreds of people deciding.
Right. Well, and that was the guy's point was that like, oh, well, if they go after the ACA or Roe v. Wade, then that's when we have to pack the courts because it's become too political. And it's just like, what kind of like narcissism do you have to believe that because you agree with the policy that your president implemented, that if we get rid of that because we, half the country doesn't think it works good and it's not working good for them, that somehow that is like beyond the bounds. They're going to start acting like that's an attack on democracy or something to get rid of Obamacare.
Yeah, and I guess the real issue here, like what I'm seeing or what I'm gathering from this is that they don't realize that the purpose of the court is not to pass legislation, period.
Right.
But they're treating it as if that was the case.
Yeah.
And it's just
right. That's just like they're completely misrepresenting what
mind-blowing.
packing.
Yeah.
Right. It's like they're misrepresenting what packing the courts means. Their people think packing the courts means if you're a Republican and you get a bunch of your guys in there. That's not what packing the courts is. Packing the courts would be to actually create new seats. Add more judges. So, all right, I'm going to go ahead and end this stream, guys, because I'm going to switch this over to my other computer so that I can work on today's video here while I'm doing that. So I'm going to swap over to that. If you are still watching, just give me a minute and it will pop up again and we can keep going. So just give it a few minutes. It will be on again. And thanks, everybody, for watching. We'll be right back.
Yep.